Why? Motion? Motion?
For motion item 1.
Yes, what do you want?
For motion item 1.
Where is the BTC? Mr. Sharma, all BTC cases comes to you only. Okay, okay. Uh, where is the BTC? Huh? Who is there? Name who?
Market settings only notice na kaya only notice. Ito na mo load ko nag-active up for us again. Advance. Equal that. Market setting looking on lang yung
Yes. What do you have to say?
Although I fear for BTC lordship, but today lordship this matter has been allotted to one of my colleagues also. If lordship only notice is concerned, lordship, then I can appear.
He is asking for stay.
The lordship kindly take a walk of that.
Mr. Sharma will just wait.
For some time.
Item 2.
Yes, what is the?
Yeah, Freedom. In this case, some other petition we have filed and that has been, notice has been issued. In some
What
other
is this matter
cases.
about?
So it's a case relating to the Assistant Labor Commissioner. The order passed by the Assistant Labor Commissioner. So our point is that this court has no jurisdictions at all. Assistant Labor Commissioner has no jurisdiction at all.
Why do you say?
Yes. Because the payment of, under Payment of Wages Act, the pensionary benefit which has been deducted, they're not deposited by the T state. The pensionary benefit does not fall under the definition of the wages.
Pensionary benefit has not been.
Yes.
Under the Payments of Wages Act.
Yes, Payment of Wages Act.
Let us see the application. This is the application. Initial.
Eh?
Initial application.
Initial application, your lordship. Page 25.
Oh, payments of wages. Where is it?
Section 2, subsection 6, your lordship. Section 2, subsection 6. Wages, definition of the wages.
Two,
Section 2, subsection 6. And exception, but does not include in the next page, your lordship. Exception number 3. Any contribution paid by the employer to any pension or provident fund and the interest which have accrued thereon, but does not include.
and what about the Code of Wages Act?
Wages Act.
Code of Wages Act. Now, these acts have been now,
Now, under this act, they have filed the application.
and that's, but then also, whatever may be, the question is as regards the Code of Wages Act. What do you say about the Code of Wages Act?
That
Because
I have not gone through.
Parliament has substituted these acts by this Code of Wages Act.
I have not gone through the Code of Wages Act.
Yes, you are for whom?
I'm for respondent number 1.
Who is he?
Union of India.
What about the Code of Wages Act? We have not, the code, what is that name? Code of. Hey, this takes care of all those, except minimum wages act has not been taken. All the labor laws. Right, Mr. Council, now I think, I don't understand why it is still being done under the Payments of Wages Act. In view of the Code of Wages Act coming into operation from 8th of August 2019. Because it consolidates all the four laws, the Payment of Wages Act, the Minimum Wages Act, and the other two acts there. The takes care of the Minimum Wages Act, Payment of Wages, Payment of Bonus Act. Like another one. All these four acts have been consolidated. And the tribunal has now been made in terms with, that has been again notified in 2020.
In this case, already notice has been issued in other cases, Your Lord.
Hmm?
Notice has been issued in other cases, Your Lord.
Okay, neat.
Let it come in admission, Your Lord.
Notice making it returnable on. When are those matters fixed?
Other matters,
Huh?
on 15/9, one matter is fixed,
15/9.
15/10.
15. I will have it later on 19/11/2025. Ms. So-and-so accepts notice on behalf of the respondent number one. Ms. Yudat accepts notice on behalf of the respondent number 2 and 3. Extra copies of this petition, of the petition be served upon them during the course of the day. As regards the respondent number 4, steps be taken by way of registered as well as by way of speed post. The petitioner is also directed to take service upon the respondent number 4 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the order dated 17/4/2025 passed by the respondent number 3,
Assistant Labor Commission,
respondent number 3, no?
yes, 3.
Respondent number 3, in exercise of the powers conferred upon the said authority by under the Payments of Wages Act 1936. The learned counsel, hearing on behalf of the petitioner, submitted that the respondent number 3 could not have passed. The respondent number 3, the learned counsel appearing on behalf of the petitioner submitted that the dispute involved is in relation to non-payment of the monthly pension, which is outside the scope of the Payment of Wages Act, as would be apparent from the very definition of wages defined in Section 2, Roman 6 of the Payment of Wages Act 1936. The learned counsel therefore submitted that as pension or any contribution towards the pension is outside the scope of the definition of wages as defined in the Payment of Wages Act 1936, the impugned judgment order dated 17/4/2025 is required to be interfered with. This court, having perused the definition of wages as defined in section 2(6), Roman 6 of the Payment of Wages Act 1936, is prima facie of the opinion that the jurisdiction so exercised by the respondent number 3 appears to be contrary to law. Consequently, this court therefore stays the impugned order dated 17/4/2025 passed by the respondent number 3, that is the Assistant Labor Commissioner Tinsukia, till the next.
Other two cases are also same, 3 and 4.
Date to silence, huh?
If the matter pertains to non-payment of dues in connection with vehicle hiring charges, Your Lordship, by the SP Kokrajhar,
Were the parties?
Lordship, State of Assam, Commissioner Secretary to the Finance Department, DC and
এছা
MTO.
বৰুৱা একচেপ্ট কৰিল আৰু এয়া হ'ল ফাইনেন্সৰ কাৰণে বি গগৈ আৰু সেইটো কৰি notice returnable on 12th of January 2026. It will be filed by 5th of January 2026. By in Lekiri. Yes, what is this? Yes. See, seeing the name, I just saw where is Mr.
My lord, in this case also, my lord, no side verification certificate is issued, my lord.
There are people out there who normally,
Side verification, they call it.
at one time, I didn't know, earlier, there used to be a time where a person who is very active in the Right to Information Act,
My lord,
asking for information, they used to be given certain prizes.
not sure.
I think here for High Court also should give some prizes. The very existence of the High Court is becoming.
Yes, yes, sir.
Petitioner. Yes, what is this?
My lord, matter pertains to, my lord, non-issuance of side verification certificate, my lord. My lord, they are asking anything, my lord. Petitioners visited the site, my lord, even though, my lord, they are not issuing the certificate, my lord. Even, my lord, no issue.
Why have you enclosed the entire thing?
My
Where is
lord,
my orders?
yes, my lord. The lordship's order will find, my lord. At page 170, my lord.
No, my lord, it is not that case.
It written on, Baba.
Here he has challenged the cancellation, not my lord,
No,
side
no,
visit
it
certificate.
written on, like,
He goes to the high case to appear, my lord.
What are you challenging here?
My lord,
don't take it.
Reevaluate the technical
Yes.
fees.
Oh, that one.
So many cases,
so
you also.
My
I tell you, na.
lord, yes, yes. I'm
Yes.
sorry, my lord, actually sorry, my lord. My lord, that challenge, my lord, that cancellation notice, my lord.
Huh?
That cancellation notice, my lord, while, my lord, they have evaluated, my lord, a lordship, as earlier, my lord, dealt with the matter, my lord. They have, whatever, during the pendency, my lord, they have cancelled the, my lord, the tender, my lord. Without any,
Oh, that one, where
yes,
they
yes,
want that particular.
yes, yes, my lord, that one, my lord.
Okay,
We have corrected it now, my lord. New tender has been issued with the correction, necessary correction.
My lord,
That particular
my
criteria,
lord,
yes.
what happened, my lord? They are going to cancel every tender, my lord, wherever petitioner is going to participate, my lord.
Let them do.
Oh.
I can't help it. We'll see
Well,
whenever they do it. But here we can only issue notice.
My lord.
Nothing more than that. As of now, no tender has been issued. Issue notice. Making it returnable. Why you are making these 3, 4 and 5 a party?
Because my lord, they are my lord, earlier my lord made eligible my lord. In that,
Maybe,
yes,
but the fact remains out here
my lord,
that the notice has, it has already been cancelled.
yes, my lord,
So you want what? You are challenging the cancellation
Yes, madam.
notice.
my lord,
So you are challenging that.
yes,
Once it is being challenged, then this court should pass an
Yes.
order to re-evaluate you in
Yes, yes.
respect to
yes,
that.
my lord.
That is too much, I suppose.
Yes.
Huh?
My lord,
Huh?
my lord. 4 and 5
That
maybe.
case,
staggered.
I-
You may ask.
For a-
Earlier tender will have to be revived, my lord. Entire proceeding will have to restart it. That, my lord, probably cannot pray, my lord.
That is too much.
4 and 5 maybe strike out, my lord.
Huh?
4
No,
and 5
even
maybe
then, my
strike
lord,
out.
for notice also, my lord. For a notice also, my lord, that will be a problem, my lord, because re-evaluating everything, reopening everything.
Nowadays, the respondent councils are also before me to get a notice also has become very object.
No.
Anyways, Mr. Counsel, cancellation has happened. What is your point out here?
My lord, without causing any hearing, my lord.
No. Cancellation, they have the prerogative. Now
My lord.
tell me,
My-
in respect to that particular contract,
Yes, my lord,
it is the opinion of the authorities concerned,
my lord.
which you must have heard it on the
Yes,
last
my lord. Yes,
occasion,
my lord.
that they require this cement, what we call CTSB.
CTSB, my lord.
CTSB they require.
Yes, my lord.
Now, have you mentioned that the CTSB is not a requirement in your petition?
My lord,
You cannot come up with all these things.
yes, yes.
You have to come up and say that CTSB is not required. On the basis of something, then only I can issue a notice.
My lord, here, my lord, the CTSB,
Why
my
did
lord.
this court otherwise challenge, issue notice in respect to a thing which has already died?
My lord, here, my lord, they had raised that issue, my lord, of, you can qualify CTSB.
No, Mr. Hawk, kindly tell me one thing.
My lord.
Whether CTSB is not required.
My lord, they had the prerogative, my lord.
CTSB, they say initially they reject what has happened in the facts, if I
Right.
remember correctly.
My lord,
A tender was issued at one point of
my
time.
lord,
You participated along with the respondent numbers 4 and 5 and others, I
my
said.
lord.
You were, during the pendency of the tender,
My lord,
while the technical evaluation was going on,
my lord.
you were asked for certain credentials of the
CTSB, my lord.
You say that, look here, they are changing the goalpost
My lord.
after the tender has been issued. That's your case.
After,
I granted a stay.
yes, my lord,
After that, they cancelled it.
my lord,
Now you have to tell me
my lord.
that CTSB is not required because it is absolutely, they are the authors of
Yes,
the
yes,
document,
are
they
the-
require
yes,
it.
yes,
Now, my jurisdiction is very limited.
My lord,
So my limited jurisdiction, you have to tell me that CTSB is not required. Where is your pleadings?
my lord, CTSB, my lord, they have the prerogative, my lord. They can require any condition, my lord.
No, you have
Now-
assailed, no, Mr. Counsel, you have assailed on the earlier occasion one thing,
Yes,
that you have inserted a CTSB condition which was not there,
not there,
and thereby you are changing the goalpost.
my lord,
Very well.
my lord.
I granted a stay. They say that, okay, we won the CTSB, so therefore we withdraw this tender. itself.
My lord,
Okay.
my lord,
Now you have to tell me,
my lord,
if they are the authors,
my lord.
they require,
Yes,
they
ma'am.
know the requirements.
They may require.
You have to tell me that CTSB is not a component which is necessary for the purpose of this contract.
My lord,
And look here, this court does not have
Yes, yes, sir.
even the expertise to that effect. You participate, do whatever you will. What is this type of challenge?
my lord,
I
here,
have understood if you have
yes,
data to the CTSB technique is not required.
my lord,
Because you cannot go back and say one thing. The SB was already there.
my lord,
And as such, not necessary.
my lord.
You cannot say now
Now,
because you have already questioned the insertion of the CTSB
yes,
then.
yes, my lord.
So therefore, you cannot go back there. So now what you can do out here is show me why CTSB is not required. And taking into account that
Ma-
this court has very
My lord,
has layman knowledge
the-
about CTSB.
my lord, CTSB, my lord, very recent technique, my lord. This is very recent technique, my lord. even they, I don't know, my lord, how the respondent number 4 and 5 had acquired that, my lord, experience of CTSB, my lord. Because they cannot show that.
So you also
CTSB
don't know what is CTSB?
Well, cement, it is only, my lord, that gravel mixing with cement, my lord. It is a sub-base, my lord.
No, you cannot say now
Yes.
that CTSB is already there in the earlier tender. You
No, no.
cannot say that.
No, no.
So you are stopped from that.
Yes, yes, my lord.
Now you have to tell me why CTSB is not required.
My lord,
That is the scope of jurisdiction.
Yes, my lord.
I think you study this during the vacations and come back to me on reopening on 15. Better.
my lord.
What do you say?
My lord, of course.
Then I'll issue notes. Otherwise, no.
My lord.
And the other part is upon the, my lord, tendering authority to decide what is required. He cannot, my lord, dictate, my lord, what should be the criteria. my lord. We want it, we want it.
Am I also not saying him the
Yes,
same
ma'am.
thing?
So, for even,
You are
even
just-
notice,
We
You
also,
are just, huh?
no, even for notice, my lord.
On notice also.
Yeah.
Notice. He is not only
Even if he says that my, it is
saying
not
anything
required.
about the interim order, he is also opposing your notice. That too, in the last week, on the penultimate day
That's-
of a vacation.
No, my lord, the public
That-
work will suffer, my lord. That's the main.
my lord, yes, after vacation, my lord, I will try to satisfy your document, my lord.
Or try your luck after 7-11.
7-11, my lord.
I won't be here.
My lord? No, my lord. I'm very,
Okay,
Comfortable with the
Mr. S.
document.
submits that he would like to go through he would like, the petitioner would like to further, and Mr. S. Hope, the learned counsel, submitted that he would require some more time in the instant matter, taking into account as to ascertain as to whether CTSB is a technique which
New-
is required to be incorporated, taking into account that the reasons, Mr. S. Hope, the learned counsel, submits that he requires some more time for preparation of the matter. So list the matter on 15/10/2025.
my lord,
Liberty given to the petitioner to file additional claims.
my lord.
Really?
Yes, my lord.
What is CTSB?
Right.
Why it is not
Yes, sir.
required?
Supplementary item 18.
Yes.
My pleasure, Lordship.
Thank you.
Lordship, in this case, on earlier occasion, directed us to instruction as regard of marking of fee on the petitioner, Lordship.
No.
Lordship, I obtained the instruction.
Huh?
I obtained the instruction, Lordship. Lordship, in the first instruction that is addressed to me, in the Lordship, I have placed a flag mark there. The petitioner was marked in the year 2011 on the basis that the ERO report is there, Lordship, page number 6, annexure 4,
Page number
page number 5, your Lordship, annexure 4.
5.
Yes, Lordship.
Order sheet.
He has been marked D on the basis of the communication received from the Superintendent of Police Mazira, your Lordship. The communication has been mentioned. There, I am reading it, Lordship. The name of Fazilul Haq
Fazilul Haq so and so has been received
from SP Nazira by letter.
communicated in pursuant to the order dated in March. So there is already a High Court's order.
Your Lordship, this order is of Mamiza Khatun judgment, Lordship. Your Lordship, the fact is, if I Lordship comes to the
Meza Khatun is those people who are already lying out there,
Lordship, that is the case.
whose cases are pending before the Foreigners Tribunal. Their names should be marked with the letter D.
Yes, Lordship, that is the your Lordship. The petitioner was staying in Nazira, your Lordship. At the time, a case was initiated against him before the Foreigners Tribunal in the year 2004, Lordship. Thereafter, the case was registered in Foreigners Tribunal, Jurhat. That is a subsequent instruction that I have placed before your Lordship.
Where?
On the another bunch of instructions I have given, Lordship.
Other next one.
Yes, your Lordship. Yes, your Lordship.
Still by.
Yes, J. Payang, this one, Lordship.
What
The
is
ca-
it?
The case is pending against him in FT Jurhat, Lordship, and the case number is FT/SVR/3468/2004, Lordship.
Where?
The very reference,
Page number?
first page number 1, Lordship. I'm reading it.
So, Viswas. Anwar Hussain.
No, in,
Begum.
his name is in page number, Lordship. 6, serial number 11. The judgment, Lordship. Fazirul Haq.
Fazirul Haq. It is his name.
Yes, Lordship. Fazirul Haq.
Fazul Haq.
Was a son of MS Diwan Sheikh.
Here the name is different.
They are
Your
speaking, but
father's name is Mohammed
not Diwan Sheikh, Lordship. Address is also Phileas Belguri.
Okay. Now what has happened?
Lordship, he has been, as of now, this judgment has been declared in the year 2019. He is declared as foreigner, Lordship.
Oh, where is the judgment?
I've given, Lordship. It is once only, Lordship. That is the judgment where Lordship has seen the cost title. It is a common order. This judgment is passed on 22/01/2019.
What is this type of order? One order for everybody?
Common order was passed by this member, Lordship.
Okay, now you are a foreigner, Mr. Soliha. So you need to take action against this. See, you got the answer so early. Instead of otherwise going out there. So we dismiss your petition, Mr. Soliha. Mr. Soliha, we dismiss.
Let me find out, my lord.
No, you can't find out. We dismiss your petition now and give you the liberty to take action against this common order.
No, whether this actually order was against me.
That
whether
is what
I
the
see
name has
this
been
and all.
given out there. That is the instruction they have placed.
My lord.
Against you, there was already an FT case. FT case has already been decided in 2014,
Let me
2019.
see. Yes.
And this FT case is of the year 2014.
10 Lordship.
What
Not
is the
4 Lordship.
2004
4 Lordship.
FT case.
And the Mamaija Khatun judgment came out 2011, Lordship.
Ah.
So in terms of the said judgment, this communication was sent by the SP, say Sipsagar, to your Lordship Dhubri. And ERO Dhubri, and he has marked him D, your Lordship, in compliance with the judgment passed by this Honorable High Court in Mamaja.
So therefore, we dismiss your petition, take steps against the 22-1.
May I have
Okay,
the-
heard Mr. D.P. Soliha, the learned senior counsel, assisted by Mr. M. Roy, Miss M. Roy, the learned counsel, appearing on behalf of the petitioner. Mr. I. Ali, the learned standing counsel of the Election Commission of India, appears on behalf of the respondent number
5 and 6.
5 and 6. 3, 5 and 6. Pusto. The case of the petitioner herein is that the petitioner is the son of one Diwan Ali Sheikh. And the petitioner's name appeared in the voters list of what is the voters list of
Persistent
132 number Belguri Part 2 Golabganj legislative constituency. Till 2013, when the name of the petitioner, when against the name of the petitioner, a D was shown,
11 Lords. He was marked D in 2011.
D was marked. No, in 2011, 10, it was there.
Yeah, in 11, we have submitted the instruction.
But I know what is written in my order. In 2000, yeah, till 2013, when a D appeared against his electoral roll, against his name in the electoral roll, the petitioner made inquiries from the superintendent of border police, Dhubri, and the superintendent of police, border Dhubri, issued a communication on 27/11/2024, 14, to the election officer Dhubri, informing that the records of the office have been checked and found that there is no FP/D voters case against the petitioner. Thereupon, the petitioner's name continued to remain as a D voter. And it is under such circumstances the petitioner approached this court seeking appropriate directions for removal of the tagged D voter against his name in the electoral rolls. This court passed a detailed order on 22/9/2025 seeking instructions from the district election officer Dhubri as well as the chief electoral officer Assam
Terror.
as to why the petitioner's name continues to remain as the voter. And if so, produce the materials on the basis of which the petitioner's name has been marked as the voter.
Terror.
Today, Mr. A.I. Ali, the learned standing counsel of the Election Commission of India, had appeared and placed before this court two sets of instructions which are kept on record and marked with the letter X and Y. Copy of the instructions, copies of the said instructions have also been furnished to Mr. D.P. The counsel who is assisting Mr. D.P. Salia, the learned senior counsel, during the course of the hearing. From a perusal of the instructions, more particularly the instructions dated 24/9/2025 issued by the Senior Superintendent of Police Boda, which is kept on record and marked with the letter Y. It appears that a case bearing number, an FT case bearing number FD/SVR/346A was referred to the Foreigners Tribunal Jorhat wherein on the basis of an inquiry being conducted by the SP bearing SP inquiry number 252/04 against the petitioner. It is further seen that on the basis of that the same proceedings before the Foreigners Tribunal, along with 15 other proceedings, were disposed of by the learned member Foreigners Tribunal Jorhat by the common order dated 22/1/2019, holding inter alia that the petitioner along with the other are foreigners who illegally entered into the territory of India after 25th of March 1971 without any valid document. This court further takes note of that in pursuance to the said judgment, an order passed by the learned Foreigners Tribunal Jorhat dated 22/11/2019, 22/1/2019. The same was endorsed by the Superintendent of Police. to the Electoral Registration Officer, Golak 25 Golokganj, LAC. And on the basis thereof, the petitioner's name it is further relevant from this court further takes note of the instructions which have been placed on record and marked with the letter X. From a perusal of the said instructions, it appears that a communication bearing number NZEL.35/2011 dated 30/3/2011 was communicated to the Electoral Registration Officer 25 Golokganj, LAC. And in terms with the order passed by the learned ordinate bench of this court in WPC number 1334/2009, dated 23/3/2011, the petitioner's name was marked with the letter D. It is further seen that your name has been struck off now.
No, as of now,
Huh?
it has not been struck off. It is marked
Why?
as this communication, the district election officer has not received this order, Your Lordship. So it's final judgment. So
My lord may see the tribunal's order also, one glance.
No,
In that case, notices were not served upon the
no,
person.
absolutely understood. No, therefore,
Without that.
Mr. Solia, I am going to
disposed of-
give you that liberty. I'm going to give you the liberty to challenge that. Don't worry.
Nobody was served. With-
It is, however, this court
Without-
inquired with Mr. A.I. Ali, the learned standing counsel of the Election Commission of India, as to whether it is not the mandate of law that upon an adjudication made by the foreigners tribunal that a person is a foreigner, the name in the voters list is required to be deleted. The learned counsel informs, the learned standing counsel has apprised the court that the electoral officer is not aware of the order dated 22/1/2019. And it is under such circumstances, the name of the petitioner continues to remain. Mr. D.P. Solia, the learned counsel senior counsel appearing on behalf of the petitioner, on the other hand, further submitted that it is unthinkable that 16 proceedings that by a common order, the foreigners tribunal have decided 16 proceedings. The learned senior counsel submitted that that is not the manner as is conceptualized in the Foreigners Order 1964. In addition to that, the learned senior counsel also drew the attention of this court that the said proceedings have have been decided against the petitioner ex parte without affecting notice. This court, having taken into consideration the above, is of the opinion that till the order dated 22/1/2019 remains, the petitioner's name cannot no orders can be passed in the instant proceedings for removing the name tag D voter against the name of the petitioner. In fact, it is the further opinion of this court, in fact, that on the basis of orders, various orders passed in WPC number 1334/2011,
11.
the name of the petitioner ought to have been deleted from the electoral rolls. First, this court cannot also be mindful of the fact that of the submissions made by Mr. D.P. Solia, the learned senior counsel, and observes that taking into account that the petitioner, the proceedings had proceeded ex parte against the petitioner, and that too at a place where the petitioner is not the resident. Liberty is given to the petitioner to challenge the order dated 22/1/2019 passed in case number FP/SVR/3468, if so advised. With the above, the incident with petition stands disposed.
Publish.
19,
My lord, in this case,
You are for the petitioner?
my lord, against Indian Oil Corporation, my lord, they floated a tender, I participated. Apparently, my lord, my bid was valid, but allotment orders were not issued to me, my lord, rather, response number 8 was allotted with who doesn't qualify, my lord. That is my case, my lord, basically. If I may take your lordship to the tender for a moment, my lord. Some
What
document,
tender?
tender for my lord,
Oh,
transportation.
Vehicle.
Yes, no, transportation of bulk LPG, my lord, by tankers. Some documents will be relevant, my lord. If my lord pays
How
it,
many tankers you are asking?
362, my lord.
Huh?
in this
In this category, 362. I offered 6. I was allotted only 2. The response number 8 has been allotted with 2. Maximum is permissible for him is 2. Under a scheme which has already been discontinued, my lord. Under a central government scheme, my lord, guarantee by the central government was there. That has been withdrawn in March. Thereafter, my lord, bank fraudulently issued a certificate to the IOC that they gave a guarantee that will issue loan to that person, my lord, under a scheme which has already been discontinued, my lord. That order also I have challenged, my lord.
No, but you are concerned with, why are you aggrieved?
Because my lord, I offered 6, I was valid. 6 ought to have been allotted to me, but 2 have been allotted to the respondent number 8, who does not qualify, my lord. He belongs to a category, my lord, which is below me, my lord. If I may take your lordship to the tender document, my lord, 3-4 documents will be sufficient, my lord.
Yes.
Page 27 is the NIT, my lord. Bulk LPG, it is the for the name of the work, my lord. Page 27, bulk LPG transportation contract by road for the state of Assam and Meghalaya, my lord. If I may take your lordship to page 35, my lord, this will reveal, my lord, what was the requirement of tanks, my lord. Page 35, clause 4. There are 2 categories, my lord. We'll see OMC oil manufacturing companies, IOC, Assam and Meghalaya 18 metric ton and above. I am concerned here, my lord, with 7 metric ton and above, the second category, my lord. IOC, state Assam and Meghalaya, 7, in the table, my lord, 7 metric ton and above. Estimated truck, my lord, is 362. These are the quantity to be transported, my lord. So we are concerned with 7 metric ton and above, which goes up to 18 metric ton, my lord. Then if I may take your lordship to, my lord, certain clause, my lord, page 42, my lord. There are 3 categories of trucks, my lord. One is already owned by a person. One is attached truck and one is, my lord, proposed trucks. If my lord sees, my lord, tank trucks, A, owned trucks. This is a truck which is offered by a owner, my lord. And our trucks are all owned trucks by me, my lord. Then second category is attached truck. These are basically trucks offered under lease. The owners are different, my lord, offered by someone else.
So there is an agreement for sale or something.
Yes,
like that.
yes, no. The owner is different. He has taken his lease on and offered to the IOC. But I come in the own truck, my lord. I own 6 trucks, my lord. Then next page, if my lord, it is relevant, my lord. C, proposed trucks, my lord. The respondent number 8 comes under the proposed trucks. I'll read, my lord. Proposed trucks. These trucks may not be available with the bidders as on the closing date of tender. Bidders may give their intent in offering proposed trucks in Annexure 22, 23, which will only be considered by the corporation in case the NIT requirement is not fulfilled as per tender evaluation criteria. So tender evaluation criteria will be relevant, my lord. Such bidders will be given a maximum period of 120 days. If we skip this, my lord, A,
So which will only be considered by the corporation in case the NIT requirement is not fulfilled, means after
propose and attach
truck and owner's truck is over.
over,
only
then he will come in, my lord. And he again, this respondent number 8 comes under a subclass of this class, clause A under C, my lord. C is proposed truck. It is clause A, my lord, will see. ST/SC, he is SC, my lord. Bidders offering proposed trucks under Stand Up India scheme of Government of India. SC/ST bidders offering proposed trucks under SUIC of Government of India must submit the confirmation letters from the scheduled commercial banks for extending loan under the Government of India Stand Up India scheme. Such bidders under SUIC on pan-India basis can offer a maximum of 2 proposed trucks, either in one bid or maximum of 2 bids in same state on industry basis. So he comes under, my lord, SC with a, my lord, under the Stand Up India scheme. The respondent number 8. Then, my lord, may kindly turn to page 68. Is the, my lord, tender allocation criteria.
And those who have not covered by SUIJS, bidder can bid one proposed truck only per
Yes.
ten.
Yes.
So he had, without that scheme.
He
only
could have
one.
offered one only, my lord. Then, my lord, may kindly produce, my lord, page 66. It starts, my lord, tender evaluation and allocation criteria.
Page
66, my lord. Tender evaluation and allocation criteria, page 66. Then, my lord, may kindly turn to page 67. It is sequence of allocation, how it will be allocated. At the clause 14, my lord, SC, ST, MSc, 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 general category. So being a SC, my lord, a person will get preference, but in that case, my lord, he has to initially come under own truck, then attached truck, then proposed truck. My lord, may kindly turn to page 68. This is the truck allocation order. My lord, this was with the NIT, my lord. This allocation order, my lord, doesn't speak about 7 metric ton and above. It speaks about 18 metric ton and above. But the principle is same, my lord. If my lord peruses in the box, my lord, number 1, this is the order, my lord, in which it will be allotted. 21 metric ton ready truck of same state, NOC from original registered state from the tendered state, or road tax of tendered state. It is owned. My lord will see it is owned. First preference is owned. Second, 21 metric ton ready truck of same state, NOC from original registered state for the tendered state or road tax of the tendered state attached. Then, my lord will see 3, 21 metric ton proposed including SUIC truck of the same state owned. So proposed truck, once it is purchased, my lord, it will be owned because proposed trucks cannot be on lease. So this, my lord, table doesn't contain anything for the 7 metric ton and above. That's why, my lord, they issued a corrigendum which my lord finds at page 104. 11 portion is at 109. 104 it starts, my lord. Relevant portion is at 109, my lord. Per hour. This is the chart in respect of 7 metric ton and above. This is the order, my lord. First preference will be to the 14.1 metric ton owned, 14.1 metric ton attached. It will go down, my lord, if I take your lordship to clause 11, my lord, point 11, wherein, my lord, I fit in, my lord. 8.5 metric ton ready truck of same state, NOC from original registered state for tendered state and road tax of tendered state. It is owned. I come in here, my lord.
Okay, now what do you want?
My lord, two more documents, my lord, 2 more documents. The respondent number 8, my lord, comes in 13, my lord.
Now, your basic case why he should not get it is first it is a proposed truck.
Yes.
Secondly, he does not come under the SUJI.
That has been discontinued by government.
And as such, he would not come under that. But he would otherwise be, can give one.
One.
That he can.
Just to show.
Now, this particular corrigendum stipulates, although in the main conditions out there, there was no stipulation as to
7.
the truck allocation matrix. But subsequently, by way of a corrigendum, they put the truck allocation matrix.
So, madam,
You call MC 11.
my lord.
Now, where does the respondent fall?
He is at serial number 13, my lord, and in that table.
So he has been given a preference.
Preference. So my lord will kindly produce page 138 for a moment, my lord. 138. It is by the nodal agency who control the scheme, my lord. 138. It to managing director, chief executive officers of all scheduled commercial banks. With reference to our letter number so and so, August 2019, we wish to inform you that credit guarantee scheme for Stand Up India has come to close on 31st March 2025. In view of the above phrase, guarantee coverage will not be available for loans sanctioned by the member lending institutions on or after 14th April to 1st April 2025. As regards the loans sanctioned during the quarter January 25 to March 25, new CG modular for taking guarantee coverage will be available till 16th April 2024. So this scheme has already been discontinued. So that preference of under that scheme for proposed track also is not available. If my lord peruses,
And when was the tender issued?
tender was issued on 1/3/2025. Till then it was not discontinued, but now he cannot offer a track under the scheme because the scheme does not exist. And despite knowing everything, my lord will see at page 157. This has
But if he had taken a loan sanction prior to that,
no, he has not taken. That is where 157, my lord may peruse. 157. Knowing that this scheme has been discontinued, it is a certificate by the bank. I have impugned this also. This is to certify that Sri so and so, resident of Duliajan, Assam, bearing PAN number is maintaining an account with the bank. Next, Sri Dhiraj Kumar Balmiki has approached for financing his project for upcoming IOCL tender bulk LPG transportation contract by road so and so. On preliminary analysis, although the credit facility is not estimated, the project is found to be economically feasible, and we shall be able to provide credit facility for the above mentioned tender subject to fulfillment norms as laid down by our bank RBI for credit facility from time to time. Security arrangement. Last paragraph is relevant. This certificate is issued at the specific request of the customer under Stand Up India scheme category for upcoming tender of IOCL without any guarantee or responsibility of the part. When the scheme was discontinued, my lord, 19.4, loan was not sanctioned. They said that we can sanction the loan. Then the order impugned, my lord, in respect of the respondent number 8, my lord.
NG National Credit Guarantee Trustee Company Limited.
Yes, my lord. That's a nodal agency who, my lord, monitors that scheme, my lord.
Scheme notification 120. 120. Number 131.
Okay, then
If my lord, two more documents, my lord, 2 pages only. One page 130 is the by which the scheme was, my
what
lord.
is 158?
My lord,
158 is what?
Letter, impugned letter.
158 is the, my lord, impugned letter in respect of the respondent number 8. My lord will find, my lord, the relevant part at 162. 162, my lord will kindly see, my lord. First table, my lord, track 1, 8.5 metric ton, track 2, 8.5 metric ton, number of truck tender awarded 2. This is the maximum limit, and category, my lord, will see SUIC SC, which SUIC doesn't exist, my lord. The SUIC does not exist, and
So here, how many trucks have been given to him?
two. That is a maximum permissible limit.
Number 162.
Page 162 is relevant, my lord. Initially, these are the rates, my lord.
These are the rates.
Yes, 162 is relevant, my lord. Same impugned order.
Following under
Then you have written.
160, that's a part of the impugned order, my lord.
161 and under following are.
Yes, Mr. Chaudhary, what do you have to say?
But last one submission, my lord, in respect of other bank, my lord, they have already issued, my lord, letters to the IOCL that we will not issue this credit guarantee facility because it has been discontinued, which I could gather today morning, my lord, could not annex with the requisition. If I may place that, man.
Okay.
I have received some instructions, may I place it? Your lordship may, my lord. Your lordship may read, my lord. Please find the below reply. Please refer to chapter 5, tender evaluation criteria that your lordship will find at page 66, my lord. Reservation minimum allocation for SC, ST and MSC is applicable at the tender level and shall override other preferences such as state of registration, wherever applicable, subject to the overall requirement. Truck allocation has been carried out strictly in line with the guidelines specified in chapter 5 of the tender document The corrigendum dated, it should be 28/3/2025, and approved truck allocation matrix. LOs have been issued to the SC/ST proposed bidders since the reserve quota for these categories could not be fully met through number one, ready trucks, number two, truck quoted under SUS and SC category. The allocation sequence followed was
What is this, the next page?
next page, my lord, regarding that, the second argument, my lord, issuance.
Issuance of
my lord-
LOA.
my lord, that, my lord, that instruction I am yet to give.
That instruction you don't have.
That instruction I don't have, but your lordship may kindly peruse, my lord, the tender document, page 66, that particular clause, my lord, is there, page 66, my lord. Clause 7 at page 66. Reservation minimum allocation for SC/ST and MSC is applicable at the tender level and shall override the other preferences like state of registration whenever applicable. So this is my instruction, my lord. Your lordship may examine the matter. Your lordship may examine the matter, my lord, we will file it.
One small thing, my lord, may indicate, small thing. Page 37, 38, my lord, 37, it starts, my lord, reservation, 38, my lord, will kindly pay. Clause C,
30?
38, my lord, 37 is the prescription of reservation, 38, it qualifies, my lord. Page 38, my lord, so clause C. If adequate number of trucks offered by SC/ST tenders are not available in a particular year, the unfilled quota may be allotted to the unreserved categories in that year, my lord. But they will get preference, but it doesn't mean that, my lord, a person who doesn't
Below me in the.
below me in the list, my lord, will come in, my lord.
So it's carry forward.
Carry.
You'll issue notice, that's good.
Some interim protection, my lord.
What in table?
At least, my lord, status quo.
Oh.
He will purchase it.
You have got,
I've offered 6, my lord.
you got two.
I got 2, my lord.
Be happy with that now.
Why I'm saying, my lord,
Snatch away the two from him. We'll consider it on the next thing.
in the meantime, my lord, if he purchases, my lord, he will have a,
No, we'll see. No equity will flow on the basis.
then at least only small premium, making it subject to outcome, my lord.
Oh, that I'm making. No, I think you will get a better order than subject to. I'll pass a better order.
Oblige, my lord.
Only thing is what the question of staying today means it is giving.
Not an absolute stay, my lord.
making
Some
it
protection, my
take-
lord. Some protection.
Issue notice, making it returnable on. You serve him by way of dusty.
My lord,
Will serve him
Yes, yes,
by way of dusty.
dusty, my lord.
Number 8.
I appear for 1 to 4, my lord. 1, 2, 3, 4.
This is admitted, the national credit guarantee. Who is going to represent?
But it's a central
Why
government.
do you need them?
That's the nodal agency for operating that scheme, my lord. There is a gazette notice I have annexed, my lord.
Understood.
For
So
the-
we can have them.
For the
as a
purpose of today, my lord, they may not be
Huh?
issued, notice may not be issued for the purpose of today, my lord. We can, if need be, my
Later we will
letter,
consider them.
my lord.
Not now. Bank of India, branch
We have
manager
served copies to their panel of lawyers.
by the stick. You effect the service through respond number 7.
Very good.
By the stick. Because otherwise matter can't be taken up on an early day.
True.
Issue notice making it returnable on 22nd of October 2025. Mr. M.K. Chaudhary, the learned senior counsel. And I get it. Mr. So-and-so, the learned counsel assisting Mr. M.K. Chaudhary, the learned senior counsel and standing counsel of the IOCL. Accepts notice on behalf of respondent number 1, 2, 4.
1, 2, 3, and 4.
No, not one.
One,
One
two,
also.
1, 2, 4.
1, 2, 3, 4. One
No,
dash.
one, two,
Dash
four.
4.
1, 2, 3. Union? No Union of India? You are Union? No Union.
We'll serve extra copies. We have served them already.
As regards the respondent number 5, taking into account the issue involved. Here also, I think respondent number 5, 6, 7, and 8.
My lord.
The petitioner is directed to take steps by way of by way of speed post by tomorrow. In addition to that, the petitioner is given the liberty to effect service upon the respondent numbers 5, 6, 7, and 8 by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next date. As regards the respondent number 9, which is the Union of India, as no standing counsel, no central government standing counsel has appeared. The counsel for the petitioner is directed to effect service upon Mr. R.K. Dev Chaudhary, the learned DYSGI, during the course of the day. The petitioner herein is aggrieved by the action on the part of the respondent authorities, more particularly the respondent number 1 to 4, in issuance in granting a contract to the respondent number
8.
8 for in respect to 2 trucks of the capacity of 8.5 metric tons under the SUIS GAP SC category. Mr. P. N. Goswami, the learned counsel, appearing on behalf of the petitioner, drew the attention of this court to the notice inviting e-tender issued by the respondent number 1. Issued on behalf of the respondent number 1 for the purpose of inviting bona fide bidders for bulk LPG transportation contract by road for the state of Assam and Meghalaya. The learned counsels appearing on behalf of the petitioner drew the attention of this court to clause 4 of the notice inviting tender, which stipulates the truck requirement. The present case, as per the learned counsel, is in respect to the 362 estimated trucks of equivalent 7 metric ton capacity and above. The learned counsel appearing on behalf of the petitioner further drew the attention of the court that there are 3 types of trucks which can be provided by the bidders. The first category is those which are owned trucks. The second category are those which are, what is that?
Attached trucks.
Attached trucks.
Page 42, madam.
And the third category are those which are proposed trucks. It is the specific case of the petitioner that the petitioner's trucks are all own trucks. And the petitioner had submitted the bid for 6 trucks. The learned counsel further submitted that the respondent number 8 did not submit any own trucks or attached trucks, but submitted the bid on the basis of proposed trucks. The learned counsel further drawing the attention of this court to clause 1(a)(c) of one CA of the, what is this document? What is 1CA?
One CA, my lord.
Of the notice inviting tender. How do you, yeah, yeah, referring to clause 1, Roman 4, capital Roman 4, numerical 1 dot numerical 1, capital C bracket A of the notice inviting tender submitted that SCR oblique ST bidders offering proposed trucks under the Stand Up India scheme has to submit the confirmation letters from the scheduled commercial banks for extending the loan under the Government of India Stand Up India scheme. The learned, it is further stipulated in the said clause that such bidder under the SUIS on pan-India basis can offer a maximum of 2 proposed trucks, either one bid or maximum 2 bids in the same state on industry basis. The learned counsel further drawing reference to clause Roman 4, numerical 1, dot numerical 1, capital C, small b, submitted that SC/ST bidders who are not covered under the SUIS scheme can bid for one proposed truck only per tender. Elaborating his submissions, the learned counsel appearing on behalf of the petitioner submitted that the respondent number 8 submitted the bid, who belongs to the SC category, submitted the bid under the Stand Up India scheme on the basis of a loan taken
Loan to be taken.
from, loan proposed to be taken.
Yes.
From Bank of India. That is the respondent
Yes.
number 6. 6, na?
6 and 7, both.
Respondent
Seven.
number 6.
Six.
6. Under the Government of India Stand Up India scheme. The learned counsel submitted that though the notice inviting tender was issued on 1/3/2025, but the said Stand Up India scheme was discontinued by the respondent number 5 by the communication dated
28/3/2025.
28/3/2025. And under such circumstances, the respondent number 6 as well as the respondent number 7 could not have granted any
Confirmation.
loan to the petitioner, the respondent number 8, on the basis of Stand Up India scheme. Be that as it may, the learned counsel submitted that irrespective of the Stand Up India scheme having already been discontinued, the respondent number 6 and 7 have given a certificate on 19/4/2025. The learned counsel further submitted that the said certificate cannot also further be given importance, taking into account that the said certificate was issued at the request of the respondent number 8. The learned counsel for the petitioner therefore submitted that under no circumstances the respondent number 8 could have availed the Stand Up India scheme in as much as the same have been discontinued. And under such circumstances, at best, the respondent number 8 could have been granted a contract only for one truck in terms with clause number Roman 4. 1C(b) of the notice inviting tender and not 2 trucks. However, the respondent authorities, in spite of respondent numbers 1 to 4, in spite of knowing that the SUIS scheme is no longer operational, have issued the letter of acceptance, and as such, letter of acceptance dated 29/2025, and as such, this is a fit case wherein the letter of acceptance is required to be interfered with. Mr. M.P. Chaudhary, the learned senior counsel, submits that that he does not have instructions in respect to all aspects, taking into account that the matter had been taken up only for the first time today. Be that as it may, from his preliminary instructions, the respondent number 38 have been given a preference, taking into account that there were dearth of SC and /ST proposed bidders, and as such, proposed bidders. And under such circumstances, even if the response, in order to maintain the reserve quota, the benefit has been granted to the respondent number 8.
And that particular clause, my lord.
The learned counsel therefore submitted that the same have been done in terms with clause 7 capital A of the notice inviting tender. Per contra, Mr. P.N. Goswami, the learned counsel, drew the attention of this court
Yes, 38.
that to pay to clause page
38, my lord.
to clause
Roman 3,
Roman 3
AC.
AC, which provides that if there are no SC or ST tenderers, then the quota can be, then the same can be filled up by general candidates, the general bidders, category bidders, and the quota can be carried forward for the next selection. This court have, Mr. P.N. Goswami, the learned counsel. Now, this court have further heard upon the learned counsels appearing on behalf of the parties on the as to whether there is a requirement for passing interim directions. This court from a perusal of the materials on record, it is seen that the respondent number 8 could not have been, perusal of the materials on record, it prima facie shows that the respondent number 8 could not have been granted, issued the letter of acceptance in respect to the SUIS scheme, taking into account that the SUIS scheme have been discontinued with effect from
31/3/25.
31/3/2025. Be that as it may, a question, however, arises as to whether there were loans taken by the respondent number 8 prior to
31st of
the
March.
issuance of, prior to 31/3/2025, taking into account that if such loans were taken, the facilities under SUIS scheme can be made, the benefits of SUIS scheme can be granted. This aspect can be learned only upon taking into account, only upon taking into account the stand of the respondents as to whether the respondent number 8 had got a sanction prior to 31/3/2025. This court also is conscious of the fact that the respondent number 8 had applied in terms with in the category of proposed trucks. And as such, the respondent number 8 has to procure the trucks within 120 days and place the same at the services of the respondent number 1 to 4. This court further takes note of that if there is no stay, in certain directions are not passed, it would result, certain observations are not given, the respondent number 8 may later on claim equity. Under such circumstances, this court till the next day observes that that any decision taken this court observes that the impugned letter of acceptance dated 29/2025 shall be subject to the outcome of the writ petition. This court further observes that in the circumstance the respondent number 8 takes any action pursuant to the letter of acceptance dated 29/2025, the respondent number 8 cannot claim equity
Deeply applied. Deeply applied.
This court further observes on the next day, an attempt shall be made to dispose of the petition. In the circumstance the said cannot be done, this court shall consider as to whether interim orders can be passed. The respondents are directed to bring on record their stand by filing their affidavits on or before 14th of October 2025. Liberty given to the petitioner thereupon to file reply on or before the next.
Dusty on 5 may be not insisted, my lord. 5 we are sending by speed post. They are in Mumbai, my lord.
I'm not giving upon 5. I'm only giving Dusty upon
6,
6,
7,
7, and 8.
Dusty on 5 is not required.
Dusty upon respondent number 6, 7, and 8. It is. This court further observes that on 6, as regards the Dusty service upon respondent number 6 and 7, the service be effected at the address of the service of Dusty upon respondent number 6 be effected at the address of respondent number 7.
Deeply.
May pay lordships. In violation of the clause 1 of the executive order and Miller clause 12, 15 and 16 of the NIT Miller, respondent authority settle the market with a private respondent who has deposited the bank draft of 2023. Normally bank draft is validity is 1 year means. Bank draft is page mailer 31. Somehow the petitioner collected it. And he has not submitted the police report as per condition Miller, and the tax clearance also has not been submitted, which is reflected in the page 28.
Your bid was how much?
Yes, Miller. I have a petitioner offer Miller 17,64,807 rupees, and a respondent number 5 is 21,04,300, which is more than 10% of the last 3 years value Miller. As per executive instruction Miller, executive order Miller, page 23.
What is the last 3 years bid?
Last 3 years, this millet, last year millet, the government has not settled the market.
But
But
then how will that apply?
they are calculated millet.
Huh?
And they are calculated. Respondent authorities are calculated their bid amount. Millet.
No, how?
Last 3 years, on the basis of last 3 years.
As per government value?
Yes,
Huh?
yes. সরকারি মূল্য pays 18 millet, বাণী millet. And in this, pays
Where,
16 millet.
which clause?
Pays 16 millet.
Hmm?
Pays 16 millet. Close 1.
Clause 12.
Close 1 millet. First, close 1.
Clause 12.
Close 12.
Page 16.
Yes. Clause 12 corresponding to executive order page 23, clause 1.
But how will that apply? Last year.
This is the executive instruction page 23. Page 23.
How will it apply? The settlement value of an asset should not exceed 10% of the average settled value of the last 3 years of these.
Yes. At the that part,
That's
my lord.
12.
At the that part, my lord, other party government will clarify that part, my lord. They have violated this order. Their guidelines, they have violated, my lord.
Notice only,
Let's
no stay.
not enclose any comparative statement also.
Huh?
No,
No,
not
enclose
enclose.
nothing.
Let's, in this case, notice may go.
Notice should I issue?
Notice may go.
Instruction may be short. for-
Notice?
eh, They
No,
are
no, no.
they are directed to
Instructions,
short
I don't
instruction.
disturb the respondent. Should I issue notice?
Let's-
Case is made out. Huh?
let's see. Notice may go.
Notice.
Notice.
Okay, at the request of the respondent and which. Issue notice making it returnable on
For vacation.
17th of October 2025. Ms. Enbora accepts notice on behalf of respondent number 1,
All respondents.
3, 4,
Four.
4. As regards the respond, extra copies of the petition be served upon her during the course of the day. As regards the respondent number 5, steps be taken by way of speed post as well as speed. In addition to that, the learned petitioner is given the liberty to effect service upon the respondent number 5 by way of the stay routed to the registry of this court and file an effective of service on or before the next day. The case of the petitioner herein is that the notice inviting tender was issued on 10/5/2025 for settlement of the Nilambar Bazar market, wherein at clause 12, wherein market for the period 2025-26. The same notice inviting tender, more particularly at clause number 12, there was a stipulation that the settlement value of any asset should not exceed 10% of the average settled value of the last 3 years of the huts, fisheries, ponds, etc. The learned counsel further referred to the executive instruction issued by the additional chief secretary to the government of Assam, Panchayat and Rural Development Department dated 25/2025, which stipulated at clause number 1 that the settlement value of any assets should not exceed 10% of the average settled value of the last 3 years of these huts, fisheries, ponds, etc. This is the specific case of the petitioner. Herein is that the petitioner had quoted an amount of rupees 17,64,807, which was within the ambit of 10%. of the government bid value of rupees 13 lakhs 20,000. However, in respect to respondent number 5, he had quoted rupees 21 lakhs 4,300, which far exceeded the 10% stipulation contained in clause 12 of the notice inviting tender, as well as clause 1 of the executive order. He therefore submitted that the bid of the respondent number 5 was invalid, and therefore the petitioner ought to have been granted the said settlement. Per contra, Ms. N. Bora, the learned counsel appearing on behalf of the Panchayat and Rural Development Department, submitted that admittedly the market in question was not settled for the last 3 years, and as such, as to whether clause 12 of the notice inviting tender can be made applicable, there are would be applicable, is required to be looked into. The learned counsel further submitted that the executive emphasis and the petitioner cannot lay emphasis on the executive order dated 25/2025, taking into account that the said executive order was issued pursuant to the notice inviting tender dated 10/5/2025. The learned counsel appeared to this court have duly heard on the question of interim directions. It is the prima facie opinion of this court that the petitioner have not been able to make out a case for passing an ex parte interim order without ex parte interim order against the respondent number 5. Under such circumstances, this court is not inclined to pass any ex parte interim order staying the operation of the
Page 31.
communication dated 11/9/2025,
Page
as
20.
well as bracket annexure D and 12/9/2025 annexure E to the writ petition. At this stage, the same shall be considered on the next date. The respondents are directed to bring on record their stand by filing their affidavits on or before next date
17.
on or before 15th of October 2025.
Humbly.
21.
Thank you, Lordship. My lord, in this case, my lord, only for the issuing of site visit certificate, my lord.
Huh?
I have come before your lordship only for issuing the site visit certificate by the respondent authority, which they are not issuing, my lord. As per page 17, kindly see, my lord.
What is the last date?
Last date 3/10, my lord.
Huh?
my lord. Let it be tomorrow, I will have the instruction.
No.
When is the last
My
date?
lord, it's only
What is
eligible.
the last date?
3/10, my lord.
310. Well, you give it to him if he has gone there.
Well, let me have the instruction, at least telephone, otherwise, my lord,
Bidder is required
There
to
may be
visit
some
the
reason.
site at its own cost and expenses to collect all necessary information and make a proper assessment of the proper assignment. Mandatory to submit the survey issued by the concerned divisional executive engineer or superintendent engineer of the concerned building along with the bid.
Page 19, kindly see, my lord.
19. 18/9 you have given.
Yes, my lord. Along with,
And
still then, my lord, the date is coming, my lord.
at 2 months, at least I should inform them, if there is a case. Or tomorrow, 10:30, I can have written information. Because since
site
there is
visit
time.
or judgment আছে না? Site visit. Site visit or judgment.
So at 2, at least I must inform them. Otherwise, my lord, these are very icy issues. On what grounds they are not issuing, at least I must inform.
Hello, at 2.
At 2.
Pending item one.
Item one. Oh, yes.
Sorry, but.
Yes, madam, here is a case where he had quoted more. Why you have not given it to him?
Lordship, I have also seen in cooperative statement, GST not submitted by him. GST not submitted,
What did he submit?
GST not submitted.
Yeah, we have
As
submitted.
per comparative statement,
We have submitted, my lord.
comparative
It
statement,
is in page 37, page 27.
page 35 comparative.
Yes,
statement.
certificate.
What certificate?
GST,
GST,
GST.
yes,
page 27.
page
Page
35 cooperative
27.
statement.
Moreover, one thing, my lord, it is that government bid money is 15,000 something, my lord. No GST is required, my lord,
And that's not
as
mandatory,
per tender notice.
but already settlement has been given on 1/8.
That is my lord. My lord, clause 5. Clause 6, my lord, up to 75,000, no GST is required. Their bid money, government money is
Clause
50,000.
8Z. 8Z.
8G, GST clearance is mandatory in case of market, so 75%, yes, Lordship. I have seen Lordship. Yes, Lordship.
What? State. She notice making it returnable on
এটা বলতো, এটা সৈতটা পূর্ণটা
22nd of October 2025. Good stuff. You, R.B. Bora accepts notice on behalf of the respondent numbers 2, 3, and 5. As regards the respondent number 1, Ms. N. Bora accepts notice, and as regards and for respondent number 4, Ms. U. Das accepts notice.
3.
Extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 6, steps be taken by way of speed post. In addition to, by tomorrow. As we, further to that, the petitioner is directed to effect service upon the respondent number 6 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next day. The case of the petitioner herein is that the notice inviting tender was issued on 8/5/2025, wherein for settlement of various markets, Gohas, parkings, farmhats, ferries, cattle pounds, etc. for the year 2025-26. The instant writ petition pertains to settlement of the what market? Polachi bi-weekly market,
Plus,
POLACHI.
some clearance should be enough.
Pustup. The petitioner herein participated in the said bid, said tender process along with 2 others. Pustup. The petitioner was the second highest bidder and had duly submitted all necessary documents as would be seen from the annexure 3 to the writ petition, which is the comparative statement.
No. Somobile certificate not submitted.
Huh?
Somobile certificate also not submitted by him.
What?
Somobile certificate.
Mobile certificate is
It is
required.
submitted.
Required, Lordship.
It is submitted, my lord. All necessary documents submitted.
Where is it?
Yes.
Bakizai clearance certificate.
Huh?
Bakizai clearance certificate is some of
Bakizai is given.
Bakizai certificate is page 23.
No, given.
Bakizai certificate.
In comparative statement, it is said some mobile certificate not given.
Not given, it is not necessary, but the fact is, where is it necessary?
Yes.
Submitted all the required documents as per the notice inviting tender. However, the respondent non authorities had issued the notice had granted the settlement in favor of the respondent number 5, na? Respondent number 6.
Six, my lord.
By the communication dated 1/8/2025. Pusto. It is the case of the petitioner that the respondent number 6 have been favored for vested reasons by the respondent authorities. Though the respondent number 6 have quoted a much lesser amount than that of the petitioner. Considering this, the above, it is the opinion of this court that the petitioner is entitled to certain interim directions. Accordingly, this court, till the next date, states the communication dated 1/8/2025, whereby the respondent number 6 have been settled with the Polasi bi-weekly market under Damdama Development Block, Wagonpara, for the year 2025-26. Gusto. The respondents are directed to bring on record their stand by filing their affidavits on or before 15th of October 2025. The records also be produced on the next day so that an attempt can be made to dispose of the petition.
Developed.
Displacement of party.
Wait, please, your lordship. Lordship will take up item number, IA number 3205, your lordship. 3053, there is a defect has crept in, so lord, I would like to withdraw that, your lord.
What is this? Implement of whom?
Parties law. In terms of your lordship's order, lordship, we have to implement the
Huh?
respondents, the state of Nagaland,
The
Mizoram.
implement of opposite party number 1 as respond number 1 and 2. And the other one is
Lordship 3053, lordship can close this, but IA lordship, there's some
Why?
defect has crept in, lordship, in 3053. Lordship will take up 3205, your lordship, IA
T2.
05,
That I will take.
lordship.
1, 2, 8.
Eight.
You want all of them?
Yes, lordship.
Mr.
And bottom, lord.
N. Gautam, the learned counsel submits that that taking into account the application file being IA number 3205
Lord.
public 2025, the petitioner would not press IA number the instant application. Accordingly, IA number 3053 of 2025 stands closed. Second one. The other one. Yes, objection from any quarters? No. Government. This is an application for impleading the respondent number, opposite party numbers 1 to 8 as respondents in the accompanying writ petition. More so, in view of the order passed by this court dated 19/6/2025 in WPC number in the present writ petition. The respondent, the other respondent, the respondents in the instant proceedings have no objection to the instant application. Considering the above, this court therefore impledes the opposite parties number 1 to 8 as respondent numbers
6 to 13, your lordship.
6 to
13.
1, 2, 3, 4, 5, 6, 7, 8, believe, huh? And 8 as respondent numbers 6, 7, 8, 9, 10, 11, 12, 13 respectively in WPC number 2716/2023. Gustav, the petitioner is directed to file a fresh memo of parties before the registry of this court by tomorrow.
Lordship.
And on the basis of that, the registry shall make necessary changes in the cost file and also update the same in the CIS. IS stands disposed. Now, in this case, we have to issue notice na, in the other one.
Lordship.
Mizoram, Arunachal Pradesh, Aizawl, and so and so. This matter immediately after on a main petition like but list this matter immediately on after vacation on 16th of October 2025, showing the names of Government Advocate Nagaland, Government Advocate Mizoram, Government Advocate Senior Government Advocate Arunachal Pradesh. Gustav.
Lordship, 7 and 8, lordship will have to take steps, your lordship.
I'm not issuing notice.
Lord.
That main matter I have to there. They are not here now because if I have to issue notice, then I'll have to issue notice to them.
Lordship.
In the meantime, you know,
I'll file it tomorrow.
inform them to appear to somebody.
Lordship.
And in the meantime, there is already a constitution of a committee.
Lordship.
You are aware of that?
Lordship, that they're likely to submit their report by 1812. The committee has to submit its report by 1812, your lordship.
I'll fix this matter
On
in
1812.
1812, na?
Lord.
So therefore, let us see what happens.
Lordship.
What is this?
May it please your lordship. This is a compassionate appointment, lordship. The petitioners,
Alveta, itna alveta pichli.
lordship, compassionate appointment.
Or
The petitioner's husband died who was working in the family court, Kachar Silchar, lordship.
when?
2016 he died, lordship. And
16.
yes, lordship.
Ah,
But
ideas have
immediately,
gone by.
lordship,
Is there-
Devabrata came 2023 or 24,
No
lordship.
case.
But lordship, immediately within 1 year, she applied, lordship.
So what?
And they have forwarded also, lordship, to consider the case of the petitioner under 2017 notification. And
Oh, what?
respondent also filed affidavit stating that his case will be considered.
Who?
Respondent.
Let them consider. They are very kind and
Consider
considerate.
what he is, both their wife and son, both are minor claiming and both are petitioner here. Both are overqualified as per the advertisement because they are applying for the post of peon. And peon, they are already a high secondary pass minor, which is non-eligible as per the advertisement.
What
In-
do they want now?
Huh?
They are overqualified.
My lord,
No,
the
lord.
post which up they are indicating. My lord.
But lordship, as per that advertisement, already appointment was lordship done by the family court, lordship.
Chalo,
So my-
wait after vacation. You file your reply against the affidavit. If you
Lord.
want. I'm a very bad case.
But lordship, Devabrata
bad
came in
judge.
the year 2023-24 and he immediately within 1 year, the
What
petitioner.
is there the compassionate appointment? If you get it within 1 year, it is okay. But thereafter, it makes no sense.
Within 1 year, they have lordship
Now, 10
forwarded,
years, how are you surviving?
but by the family pension, lordship.
How fantastic, you have a family pension, then where is the question now?
They were both of they were.
Yeah,
But
your
lordship,
son,
that is
your
another,
son,
son is studying, lordship. He attained majority, lordship, so I made him petitioner number 2. And according, after attaining majority, he applied, lordship. And mother says, lordship, in
where
my,
is studying?
in the college, lordship, is a
College.
4th semester, 8th semester BA, lordship, graduation.
BA,
Yes, Lordship.
BA 8 semester is there nowadays.
Lordship, maybe I
They
don't
can be
know.
6 semester.
As per information, Lordship,
BA has become different now.
last
3
semester
years.
BA or 5 years course, I have no information.
No,
Last
that is
Lordship.
important. If
Lordship.
he is on a some technical institution, he has the money to pay.
Lordship, then I will
It's why
file
the question of
reply
compassionate appointment.
enclosing all these
That
information,
is-
Lordship.
Okay, not on the last day, one penultimate day about their not to dismiss. Let the matter of the vacation on 23rd October.
23rd October, Lordship. 23rd October. Public.
Nine.
In the meantime, liberty given to the petitioner to file reply.
Public. Lordship.
What is this?
Overqualification. His high secondary pass requirement is class 8 to below high secondary. Similar matter of your lordship has already passed.
Where is he? No one is appearing. Oh. Nobody is appearing, na?
Nobody.
There was a stay.
No stay.
Okay, none appears on behalf of the petitioner on call.
Oh,
What have you done? Terminated him? What is
Yes.
the case? Huh?
yes, my lord. 13-10-23.
What? 13?
10-23. Page 34.
The petitioner herein is agreed by the order. Mr. H.K. Das appears for the Guwahati High Court. The petitioner herein is agreed by the order dated 13-10-2023, whereby the petitioner's services as a grade 4 peon in the establishment of the district and sessions as Kokraja was terminated from service. The reason for termination was that the petitioner had at the time of appointment pursuant to the advertisement dated 22-2023 did not disclose that the petitioner had passed class 12. Subsequently, when it came to light that the petitioner had already passed HSSLC, the petitioner's appointment was terminated by the impugned order dated 13-10-2023. This court further finds it relevant to take note of that similar matters have already been disposed of. Similar issues have already been disposed of by this court by an order dated 27-1-2025 in WPC number 7533-2023, wherein this court had categorically held that when the petitioner was not eligible and not disclosing the fact that the petitioner was overqualified, the appointment of the petitioner was illegal, and as such, the appointment of the order of termination cannot be said to be illegal. Considering the law, considering the proceedings, considering the above, this court does not find any merit in the incident petition, and as such, the petition stands dismissed.
Much
Ten.
deeply.
Lordship may kindly peruse the
You got
last
the
order.
money.
No.
Yes, well, that money has been paid according to the
Yeah, the money has already been, financial sanction has also been granted.
Yes.
Yes.
my lord.
Then have you paid?
6
on-
lakhs, yes, my lord. The accounts officer judicial in the establishment section, his note dated 8/9/2025 says that this has been paid to the.
I have no instruction.
Get your instruction. Ms. S. Sharma, appearing on behalf of the Guwahati High Court, submits that as per her instructions, the petitioner have been paid his
An amount of 6,54,173.
paid an amount of rupees 6 lakhs
54,173, my lord.
173. And as such, nothing further remains in the instant proceedings. The said payment, the learned counsel further submits, the said payment was made on
That was paid on, my lord. Twenty-six, no, my lord, that is his bill. Uh,
why you have no
36,
Huh?
the bill dated is 36, well, the date of payment is,
When was it credited to the bank account?
that I'm trying to find out, my lord.
Let me come at 2 o'clock. my lord.
Get your instructions, we can close it if the matter.
Yes.
Yes.
That's all.
Unnecessary keeping these matters.
Yes.
Okay, no problem.
Item 12.
In this case, PPO already issued, my lord, to Treasury officer, my lord.
Huh?
PPO, my lord, issued.
This is
On 12/9/2025, my lord. My friend also, directly take instruction, right?
What do you want?
This is regarding pensionary benefits, Lordship. I have petitioner has received a copy from the Accountant General.
But why the matter is before me?
Yes, Lordship, that is done.
I don't know.
I'm no bad. This is not a matter before me.
Yes, my lord, because my lord, this bench,
Either a bench matter or.
Bench still-
This has nothing to do with the High Court.
my lord.
No. That this court is not taking up this roster. List this matter before the appointed bench.
Oh, no, it's 13.
My lord, in this case, my lord, affidavit prepared and my lord, heading also done, my lord, we have penned it for signing. But he has already, my lord, the district, the Hailakani transferred, my lord. Probably that's why it is not returned back to me. So,
Mr. T.K. Mohanto, the learning planning council of the Guwahati High Court submits that the affidavit could not be filed in view of the fact that the district judge,
this is a Hailakani.
Hailakandi, have already been transferred and further seeks for 3 weeks' time in that regard. List this matter on 30/10/2025.
My lord,
In the meantime, the affidavit be filed without fail
my lord, develop.
on or before 27th of October.
Supplementary item 22.
My pleasure, Lordship. My lord, item number 22 and 23 are similar.
Regarding my lord, release of security deposit at 2, my lord, the instructions are put down. At 2. No, last chance was given, that's why I'm saying at 2.
Hello, you pay interest 17%, 18%.
They may verify, and if I am entitled, my lord, they may release the money, my lord. I will also pay for
Why
the,
you are going on that?
my lord.
You gave them now, they pay 18% interest.
Obliged, my lord.
Because they are delayed.
At 2, my lord, there won't be further delay, my lord.
Mr. Gogoi, yesterday I passed an order where
Yes.
I put the notice.
In the contempt.
An order to the chief secretary.
Yes.
Copy of that order will be given to you.
Yes, immediately I will come with it.
Because why, you see, other orders are different,
My lord,
but here, if it is a delay,
my lord,
interest is.
accruing, my lord.
See, after all, your money, my
Every
money,
money.
everybody's money,
I understand.
which is being affected. So therefore, whenever there is, more particularly land acquisition,
That's
you cannot stay, the finance cannot, and you gave, the PWD had granted a sanction in 2024.
there are lapses, I suppose.
Maybe it has left. But it has to be urgent because you are paying interest is 15%.
Lordship,
Then there is an order passed by the division bench.
I understand.
So therefore, if you don't keep on delaying it,
Lordship.
that officer has to be taken into task. Then also, then will happen. That is why the order will be given to you, you give it to.
Yeah, I will communicate.
Then only things will move. You are very serious. Anyways, you have it after vacation, no?
Lordship. After immediately and then on 13, my lord.
My lord, your lordship raises the last order, my lord, for
I've
the
seen it last order.
last second 2 occasions, my lord. They have said that this is our last chance. They had prayed for a last chance, my lord.
You have not got your instruction.
But at 2 a.m., just now I was, my lord, having a chat with the my lord licensing officer. He said that he has communicated. Now probably by 2 he will come. Even oral instruction I will place.
Okay, two.
All right.
This is the third matter of yours. 3 matters now at 2 because of.
No, 2. Second,
23.
One is that-
total 2 matters, there are 3.
These two.
Total
20? Log on to K.
No, this is a matter, I'm sorry.
To lagi betul. Maka tu lagi. What is this?
Look, this is a matter regarding MACP Dhubri. Here the petitioner has challenged the show cause notice and suspension and everything, my lord. Lordship will remember the case of Anju Prasad. Anju Prasad, MACT Dhubri, your lordship was pleased to observe that minimum penalty should be sanctioned, not more than that. Husband and wife, he is the husband, my lord. So show cause notice was issued for taking leave in an improper manner. So thereafter, in wife's case, your lordship was pleased to my lord, give a liberty to take a call in the proceeding. She was exonerated. So here, if this writ petition can also be disposed of, because inquiry is over, inquiry officer has recorded some finding, my lord, holding the same to be proof. I have already communicated to the my lord, member concerned there. So if
Censure.
in fact,
Censure.
yes,
7(1)(a).
7(1)(a), my lord.
even
Nothing more than that.
even the disciplinary authority considered the thing and exonerated the wife. So perhaps if your lordships dispose of this, directing the disciplinary authority to take a call, then perhaps, my lord, the same fate will be there.
One judgment of Justice Surya Kanta on the proportionality aspect.
Well,
It laid down 6 or 7 parameters. Like that's very recently given. The proportionality parameter. You have a look.
may I know the name? Or I'll search for that, my lord. I'll search.
I give you.
But one judgment I know of Justice Abhay Oak,
No.
that a bit in respect of a bank employee.
No, this is recently. This is a very recent case.
Lordship.
Sunil Kumar Singh. 2025 SCC online SC 439. There, the parameters have been laid down
Yes.
on what are to be taken into consideration. More particularly at paragraph number 60. Guiding principles for courts consider while scrutinying the proportionality of action taken by the House. This was by the House against the member. We clarified that the parameter. Degree of obstruction, whether behavior and all these things are to be taken. Expulsion, there was an expulsion made in the Manipur thing.
Lordship.
This will be required for the other matter. HG Guhai, what's her name? HG Gulwa. That lady, advocate, I passed an order, na, don't pass that order out there. The judicial authority department shall not rely upon this punishment as a precedent. Remember that?
Yes,
case?
yes, yes, yes,
That
yes.
was a case where this particular, because this is very important, this is the first time it has happened.
That appeal was pending and your lordship was pleased,
pending,
yes.
Yes. There, so therefore you have to look into this when you
Yes.
are the next event. When I have put the question as to whether minor or major penalty can happen to it. But apart from that, you have to look into it on proportion. Anyways, Mr. H.K. Das, the learned standing counsel of the Guwahati High Court, submits that the inquiry proceedings are almost over and the inquiry report have been submitted. It is only the disciplinary authority is required to pass necessary orders. Taking into account the above, list this matter on 30/10/2025.
Some order has to be required, Milord, has to be there by your lordship because there was an interim order not to pass final order in the DP. So some observation.
30/10/2025. First of all, taking into account this court further takes note of that in similar circumstances, in respect to the same incident. Same incident, na?
Yes, same incident.
In respect to the same incident, another employee has already been exonerated.
Yes.
Considering the above, this court believes that the disciplinary authority shall maintain, the disciplinary authority shall apply the same yardstick. In that view of the matter, this court modifies the order dated 23/2025 for order
24,
dated
24, my lord.
23 to 24.
24, thereby giving liberty to the respondent authority to pass appropriate orders, keeping in mind the above observations.
My lord.
Much of this.
May I please? My lord, in terms of the earlier order, my lord, we have filed, my lord, affidavit in reply as well as additional affidavit bringing on record the, my lord, dusty service served on the respondent number 6.
What is your stand now?
Lordship, we have published in the newspaper, NIT is published in the newspaper. First, NIT was cancelled due to too much high rate, so we cancelled for earlier one. And second one is published, he has not participated.
Huh?
Second NIT, he has not participated.
No. Here, was duly informed about the complaint that the earlier tender dated so-and-so was cancelled due to abrupt rate of bid value in comparison to the previous rate. The petitioner thereupon in the last week of July came to learn that in the meantime, on the basis of a notice in the fishery in question was settled in favor of the fund number 6 for a period of 3 years. As submitted by here the learned counsel for the demand that the petitioner. Have you filed your affidavit?
Affidavit filed, Lordship. Affidavit filed.
Affidavit filed.
Filed, Lordship. Page
Reply
35.
filed.
Page 35.
Chalo. Somebody is running.
Respondent
Service,
No,
number
Lordship.
service is complete upon the respondent.
Yes.
Hello, we have it after vacation immediately. This court duly takes note of that the service upon the private respondents are duly complete, as it appears from the additional affidavit filed by the petitioner on 18th of September 2025. Accordingly, this court deems that the service upon the respondent numbers
6.
6, na?
My lord.
Respondent number 6 is duly complete. It is further seen that the affidavit has been filed by the respondent number 5 and the petitioner had also filed a reply. Taking into account that you are not filing affidavit. No. This quote further. This quote further. Inquired with Mr. P. Sharma, the learned counsel who appears on behalf of the Fishery Department as to whether the Fishery Department would file any affidavit. The learned counsel submits that as per his instructions, the Fishery Department would not file an affidavit.
Has fishery has been handed over to them?
As the fishery had been handed over to the British authorities. Accordingly, list this matter on 16th of October 2025 at 2 p.m. On the same day, an attempt shall be made to dispose of the litigation.
My lord. Deep lawless.
17. 21.
My lord, it's on vetting stage, my lord. The affidavit, my
Mr.
lord,
G. Boisho submits that the affidavit could not be filed as the same is at the vetting stage. Okay. You are enjoying a stay, na?
Yes, yes.
Okay. We have it in the month of January 2020.
My lord.
Take
My
your
lord.
time, fine.
My lord,
Taking
October,
into
my lord.
account the-
Or no,
this-
first week of November, my lord.
19th January?
First week of November. My lord.
No.
I'll leave it to your lordship, my lord. I am helpless, my lord. I cannot improve, my lord.
Taking into account that it takes some more time for the purpose of filing the affidavit and the affidavit being essential. List the matter on 2025. Interim order passed earlier shall continue till the disposal of the.
I have received an affidavit from respondent number 6 yesterday only. Private respondent.
Whatever you want to file, file. It's the matter on 2026. Because the interim order passed earlier shall continue till the disposal of the litigation.
Item 25.
Contempt case, R. Babudari, what is this?
So, my lord, your lordship kindly see, it is a contempt. It's a
Very
contempt
well.
petition, my lord.
Fine.
Your lordship kindly see order dated, my lord. Order dated, my lord, 3/37/2025.
By 6 weeks time has been sought for completion.
37, my
For-
lord. 30.
for release of funds of knowing after due financial form. Not completed process.
Not completed process, they have filed an affidavit. Now they are just like a sitting over the division bench, my lord. They are now again, they are want to examine, my lord.
What? What is that order? Let us see.
Your lordship kindly see order dated, yeah, the main, page 10, my lord.
It's 10. Really? In the order, TJ Mohanta.
And 11 portion is page 15, my lord. Relevant portion is page 15, my lord. Is appeared from the page 15, my lord. Today, when the matter has been called and instruction dated,
Then against that you have filed an appeal.
no,
Why you are sitting division bench?
no, my lord, now, my lord, your lordship kindly see, they have, there is a order passed by your lordship.
Ah.
On time. No, I am,
Did I pass?
no, as if, my lord.
Arbupazari, the learned counsel appearing on behalf has placed an instruction issued by the joint secretary whereby 6 weeks time has been sought for completion of the whole process of release of the funds to the petitioner following after due financial norms and procedure. When the said aspect is mentioned in the being submitted on behalf of the respondent number 1, the same shall be an undertaking by the respondent number 1 that the process to be completed within 6 weeks of the day.
And now they file an affidavit stating there, no, I will go, I need another, inquiry will be made. That is their case.
What inquiry?
But I don't know, well, that's why I'm serving in the, as if they are division bench, my lord.
What is that inquiry? Where they are saying?
Lordship may be pleased to take up the affidavit, my lord. Filed by my lord R1, my lord. Their lordship will find, my lord, at page 27, my lord.
Yes.
Page 27. Is it photo order to the
Then? Then what? What is your stand?
Then, my lord, in the, my lord, writ proceedings, my lord, my lord, when the writ petitions were disposed of, these matters pertains to, my lord, non-payment of contractual bills, my lord. Now, when the writ petitions were disposed of, there are two writ petitions, hence there are two contempt petitions right now, my lord. So when, my lord, the writ petitions were disposed of, my lord, at page 15 of the contempt petition, a part of that order, today when the matter is called, an instruction dated 22/5/24 has been placed before this court by Mr. A. Bhattacharjee, Learned Standing Council Revenue, issued by the Joint Secretary, indicating that the bills of the petitioner shall be released within a period of 3 months. So that was the instructions given to us. On the strength of that instructions, my lord, these writ petitions were disposed of. Now, my lord, after the writ petitions were disposed of, my lord, they were not paid with the money. So therefore, my lord, they have filed these contempt cases. And in the contempt, in the present contempt proceedings, my lord, we on 37/2025, your lordship was pleased to pass an order, my lord, on the strength of instructions what we had received, my lord, from that department. We made a submission, my lord, that within another 6 weeks' time may be granted for completion of the whole process of release of funds to the petitioner following all due financial norms and procedures. So this was the instructions given to us. That was dated, my lord, 29th of July 2025. Now these instructions having been placed before my lord was pleased, my lord, by order dated 37/25, my lord, to produce a compliance report, and last opportunity was given to us. Thereafter, my lord, we have filed this affidavit, my lord.
Understood. Now, what do you want to do?
Lord,
You see, whatever may be, there is a direct problem arises.
Absolutely,
when you
no
give
escaping.
Instructions like that.
No escaping, yes.
Huh?
No escaping. I cannot escape, my lord, from the rigors of the
No,
court
but
order,
thing is, one
Yes.
thing one has to understand.
my lord.
That officer who has given that instruction that they are going to pay.
Absolutely, yes, 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 yes.
What action have you taken against? Why he has given that instruction in that matter? You cannot escape saying that this particular officer has given it. If he must have been taking it as if the court is there, okay, let us get this order first, then we'll see later on.
My lord,
Is that the attitude of the finance or the revenue department?
No, my lord, they are doing
It
it.
seems so. You take the things that the court is very taking it lightly. Yesterday, one matter. Finance, that is what I was telling Mr. B. Gogoi. The court had directed to pay an amount of 3 lakhs initially. On the question of land acquisition cost of 3 lakhs, the court directed them. That person went and filed an appeal. The division bench say that as per section 80, he will be entitled to interest from the date of dispossession, that is on 2004.
Yes.
That amount became 11 lakhs. Okay. In 2000, PWD comes up and says that we have made the financial sanction, but if state finance is not clearing it. I've issued an order to the chief secretary and all. Now, who shall be responsible for payment of these 11 interest at the rate of 15%? Because it is a delay of the finance department. They can sit over. Contractual bills is the different thing, but infraction of 304 is 300A is also a different.
Absolutely.
And that too when there are orders.
My lord.
These are public money. Now, on what basis, if there was no verification, he had given this undertaking that within 3 months the government is going to pay? What action have you taken against that officer to now to come up and say that this particular affidavit, we have constituted another committee?
Right.
You have to say that that particular person you have suspended because of what he has done and given a false incorrect information before this court, which resulted in passing of that order.
Yes.
You have not taken anything to that effect. So under such circumstances, why on earth this court should not hold this respondent number 1 to be in violation of the court's order and initiate contempt proceedings against him? Initiate contempt notice. This is not done. They take it, as if it seems that the government of Assam is taking the things very lightly. He has to categorically say, this particular officer, who is this, Gyananda Dev Tripathi, he has to particularly say what action has been taken, that without making a proper verification, why on earth he has come up and said that within 3 months we are going to pay. This cannot happen like that.
I can only pray, my lord, if lordship may be pleased to.
No, you have, if you want to take action against,
No, I have
if you
nothing to
show,
submit.
yes, he had without instructions, without making verification, he has made this, and for that it has resulted in disorder. If that be so, why on earth have you not filed a review?
My lord.
But you cannot take it like this. You give an
Absolutely.
instruction and we believe. Then on that basis, we are not going to believe any of your cases of any of the statements being made by the government councils.
The lordship is correct.
After vacation, should we put it out there? That we are not going to trust any of the government councils or any of the instructions produced.
True, my lord.
And every case they have to file an affidavit.
Here only affidavit is there, my lord, on the basis of affidavit also. In the judgment itself, they have affidavit quoted, they have what they have stated, my lord. Not only instruction, my lord, affidavit also there, my lord. They have quoted in the.
The
affidavit.
Chief Minister's Vigilance Commission, whoever it is, they give a clean sheet. And thereupon you say that within 3 months you are going to pay. Now you have another body. This cannot happen like that. Who filed that affidavit? We'll take it up after vacation, Mr. Mohanto.
Fine.
Let me get the petition also take the law
My lord.
and then pass orders against that officer who either we direct the authority to take, as they are submitting that they are still going to go for that, means he has given a false affidavit. So against them, why proceedings should not be initiated for filing false affidavit, ask the Registrar General to file an affidavit against these people. This cannot happen like this. One has to be strict. You cannot file affidavit in this manner. And otherwise, normally what orders do we file? We say make verifications
Yes.
and then pass. Pay. This is how we do. In cases where there are affidavits filed, then in that affidavits, then on the basis of the affidavits being accepted, then we do it.
Yes.
In case affidavits are not filed, instructions are produced. We put the instructions
Yes.
and then also we ask for verification and pay.
Yes.
But here you keep on undertaking that we have done everything and therefore we are ready to pay within 3 months.
Here in both quoted, my lord. Affidavit also quoted, my lord. Instruction also quoted in the judgment.
Okay, we do one thing. We'll take action against this particular person.
He is no longer in the department, my lord.
Not necessary. He was responsible at that point of time. You want another person to be also beheaded along with him. Give the name. Mr. Barbuzari, who is there? We'll again make him also. Along with him, another person be made party out here. Who else? Who is there in the department? Mr. Barbuzari, who is there in the department?
Now, my lord, he was the principal secretary at that point of time, my lord.
Now,
Now, my lord, the additional CS is there and other joint secretaries are there. And therefore, lordship has passed that order, my lord. Lordship will kindly see, my lord, order dated 37/2025. My lord, this is the basis, my lord. Because on instructions, lordship has passed that order. And lordship has perused that instruction. Lordship may be pleased, my lord, at the most, my lord, lordship may be pleased to, my lord, take a call on him, my lord, on that, my lord, gentleman, my lord, who is the joint secretary to the government of Assam. Lordship will kindly peruse this, my lord.
Shyamal Setra Gogoi.
Yeah, this is my instruction dated 29th of July,
That is
2025.
what I'm looking at. I'm putting it as X.
Yes,
The Honorable High Court may be pleased to grant 6 weeks' time for completion of the whole process of release of funds to the petitioners following all due financial norms and procedures. This is the particular document.
yes.
Then give us something to that effect by which we can also take come to your rescue. But you are not giving us anything. You say that we are looking into it and we have now formed another committee to look into it.
Lordship will kindly grant me, because it is not that, my lord, that we are running away from our liability, my lord.
No, it is.
We will have to pay.
No, I don't understand. Whether you have to pay or not is a subject matter of verification.
Yes.
Did you verify that that he is entitled to payment at the time when you submitted before the learned single judge?
Well, that verification, my lord, therefore, Lordship. may
And if
please
there
to-
was a verification and on the basis of which an affidavit has been filed, it is your bounden duty to honor that.
Yes, absolutely.
And if you don't honor it, then no problem.
Lordship.
We put it on next time here, along with no senior advocate mentioning and all this thing, we'll mention this. That
My lord,
not
Lordship,
the word of the mouth of any of our government councils or standing council cannot be accepted. They are to place only by way of affidavit. Okay?
Lordship,
And put your name with, and the person is bold letters your name.
absolutely, my lord. I am always, my lord,
But this cannot happen like this.
exposed to Lordships, my lord.
Okay.
My lord, what I can pray, my lord, today, my lord, what I can pray today, we have filed an affidavit. If Lordship may be pleased, my lord, to fix this matter post vacation, taking along with the
That is what I'm doing it.
Lordship will verify, and thereafter Lordship, because, my lord, what I can understand, this instruction dated 29/7/2025 is
The
the
29/7 is different. I'm not on 29/7.
here,
The moment there you are still using the word certain financial formalities that can be twisted somehow. So that can be seen in that all we have looked into the financial things we need to further look into it. That is another aspect. So whether 6 weeks are there, in fact, there is a recent judgment of the Supreme Court also said that if there is a delay, that doesn't amount to contempt. That is by Justice Gavai and another. That is there. We are aware of that. We don't want to embarrass the officers, but don't put us in such a position that we have to do it. And it would not look nice if
absolutely,
we have a contempt proceedings initiated against a high-ranking officer. We
Absolutely.
don't mind to do so, but it would not like nice. So don't also put us into an embarrassment for taking action against them. We don't mind to take action, but don't put us. But this is what you are doing.
my lord, what I am respectfully submitting, my lord, let this matter be posted after vacation,
yes.
along with the read codes.
This court have duly taken note of the
record.
affidavit filed by the respondent number 1. Pusto. Taking into account the stand of the respondent number 1 in the affidavit, this court fixes this matter again on 17th of October 2025. Pusto. The registry shall also tag along with the petition, along with the instant proceeding. Tag along the records of WPC number 3573/2019. Pusto. Liberty given to the petitioner to file any reply against the affidavit filed by the respondent number 1.
Next is also same.
Second contempt is
Same,
the same. my
same,
lord.
my lord,
We have filed an
repetition.
identical affidavit there. There the repetition number is
Same.
different, my lord.
Okay, you will take it.
Repetition and different.
That
Lordship. Lordship.
Over. Main list.
May I please, Lord?
27 is there, na? We'll take it up at 2.
May I indulge, Lordship?
Huh?
May I indulge, Lordship, indulgence of this, Lordship? An affidavit have to fix a matter, affidavit I may be allowed to, I may be allowed to call an affidavit, item number 11, Lordship.
Item number?
11, Lordship.
Okay.
I love that.
Apology, my lord. Item number 25, your lordship, item number 15, your lordship was pleased to fix on 13/10. Item number 15, my lord, may I pray to take up this matter in the second week of November because the learned member will be out of station, my lord. Second week of November, any date, my lord.
25, 10.
25, no, my lord, 15, item 15.
No, I don't think so. High Court matter, no?
High Court matter, your lordship
No, no,
on
no.
1310, your lordship has
It
fixed
is
on
1311.
1311.
11.
Oh, I am told by 13. I'm obliged, much obliged.
Because it's always on Thursday. 1310 is a Monday.
I'm sorry, I'm so sorry. Much.
Yes.
You turn over bench, item 1.
May it please your lordship. My lord, we have filed our affidavit in reply, my lord, in respect to the, my lord, affidavit filed on behalf of the High Court. Now, my lord, earlier the government had filed an affidavit, my lord, nothing much was there. Now they have filed an additional affidavit.
You are working in the registry. The Guwahati High Court.
My lord, I'm sorry, my
Mr.
lord. it's not
Pangi, you are
working.
working in the registry of the Guwahati High Court.
Yes, my lord.
Then we had, there's a particular committee which has been formed for the purpose of looking into the pays of
My
the
lord.
employees working in the Guwahati High Court establishment.
My lord.
So they are to submit a report on 18/12/2025 before this court. I'm taking up another matter wherein
My lord.
National Employees Association is also made a party in that proceedings.
Yes, my lord.
So there, we will wait for this matter for some time. And in the meantime, you submit your representation before that committee. Who is appearing for the High Court? Anybody from the
I'm
High Court?
appearing.
I'm sorry, my lord, is not audible. Man.
That committee which has been formed now for
Yes.
the pay and all these things for all the four seats of the Guwahati High Court.
Pursuant to your lordship's
My
order.
lord.
So
Yes,
that committee, let the committee look into this case of
I
the
think
prisoner.
it's better. It's
Huh,
regarding
better.
pay, my lord.
Regarding the pay has to be same with, he's a record, serving as a record keeper in the registry of the Guwahati High
Record keeper,
Court.
my lord.
And
Yes, record keeper.
he says that he should be given the post equivalent to the post of assistant section officer in the Arunachal Pradesh Civil Secretary.
Secretary.
It
Yes,
can
my
be
This is an issue which requires to be examined by that committee.
Yes,
And then we will take up this matter along with that matter on 18th.
fine, fine,
Huh?
fine. That'll be better.
Mr. Panging, you do that. Can you hear me? Mr. Panging? Hello. The petitioner herein is aggrieved in the pay disparity in as much as it is the claim of the petitioner that the petitioner has been, who is a record keeper in the registry of the Guwahati High Court, Itanagar Permanent Bench at Nahalagun, is paid an amount of rupees 35,000 as the basic pay. Whereas it is the claim of the petitioner that the petitioner's pay should be equivalent to that of the assistant section officer in the Arunachal Pradesh Civil Secretariat at Itanagar. This court, in another writ petition being WPC number 72716/2023, had passed certain directions for constitution of a committee for the purpose of making a pay rule in terms with Article 229(2) of the Constitution of India. Taking into account the above, now in pursuance that a committee has been constituted by the Honorable Chief Justice with a mandate for the committee to submit a report on or before 18/12/2025. The said writ petition being WPC number 2716/2023 is also listed, has also been directed to be listed on 18/12/2025. Considering the above, this court directs the registry to list this matter on 18/12/2025 along with WPC number 2716/2023. In the meantime, the petitioner is granted the liberty to submit a representation before the Registrar General of the Guwahati High Court, who shall forward the said representation to the said committee. List accordingly.
Much obliged.
Obliged.
Principal seat item 10, it's the 2 p.m.
Receipt.
Mr. Chatterjee, the learned counsel appearing on behalf of the petitioner submits that in pursuant to orders passed by this court, the petitioner has received an amount of rupees
6,54,173.
173 as towards the full and final satisfaction of his dues. The learned counsel therefore submits that the petitioner would not like to further proceed with the instant writ petition. Ms. S. Sharma appears on behalf of the Guwahati High Court. Taking into account the above, the writ petition stands closed on withdrawal.
Item 11.
May to the lord. The petitioners, the Shamabai Shamiti, a cooperative society, in pursuance to an notice inviting tender by the Assam Fishery Development Corporation for the year from 2024 for 7 years for settlement of a fishery. Notice inviting tender was issued, page 25, annexure 1.
Yes. Volcana.
My lord?
Volcana.
My lord.
Then what happened?
Page 25, annexure 1. My lord, thereafter at page 29, your lordship will find there were 2 stages, technical bid and financial bids. Page 29, your lordship will find annexure 2, this the third column, Borpete, then serial number, our name was there, madam.
You are qualified.
I was qualified both in technical and Malada financial bid. Page 34, your lordship will find.
Financial bid is different qualification.
Well,
First, you have qualified for the purpose of financial.
I was technically, I was qualified, then that stage also I was recommended, madam.
Then
At page 34, my lord, your lordship will find list of documents that I have to submit. Description of the documents, serial number 12, list of fishermen, and 16 is copy of the authority letter in case of Shamiti. My lord, that is the list, my lord. Thereafter, my lord, at page 36, your lordship will find the particular clause, 6.6. A copy of the resolution of general meeting of the society in providing grant of authority for tender in case of fishery cooperative society, the committee shall attach a list of their existing members. That was the clause given thereafter, Malad. Malad, and page 38 at 10.2. The tender documents will open at the time of opening the tender and corporation will note the state documents. The corporation will prepare a list of documents received from the tenderer and that the list of documents will be signed by the department officer and the tenderers jointly. A list will be prepared, signed by both. And copy of the list will be furnished to the tenderer. In the latter stage, if the complaint of misplace of document is filed,
the corporation will not be responsible. Of course, the documents.
Okay, why are you agreeing?
My lord, thereafter, my lord, there was inquiry held on the basis of a complaint at page 40, the inspection report at page 41, that was the inquiry report. The secretary of the society has not maintained the members register of the society properly. This is dated
It
18th
has
of.
been settled in favor of one Manoj Das.
Now it has been settled in favor of Manoj Das. He is
Why
the
are you agreeing?
I am agreed because my lord, they have cancelled me on the basis of this inquiry report, and now they come and say that 6.6 clause you have not performed, or you have not maintained the 6.6 clause.
Where is that?
My lord, the impugn order, my lord, before that, if your lordship just permits me.
No, don't count so much. After that, if you want to show so many things, then have it after vacation.
Page 69. And
No court is taking up for final disposal on today, except.
except,
So therefore, if you have to be very quick.
my lord. Page 69.
It is found that Joydev Das does not submit the list
Joydev
of
is the secretary.
members
Send
of
me a
the
list of
society
members society as per clause 6.
company.
The instant submission of the original copy of the authority letter and non-submission of list of members along with tender bid vindicates the stand of the report of the cooperative society dated 29/11/24. As per the cooperative section 45, any meeting has to be, as per bylaws and register, has to be given approval of the same. In that case, the original copy of the authority letter, which is shown as a part of the procedural meeting held, cannot be annexed along with the NIT, hereby giving the original copy casts doubt on the bid document submitted by Judge Das. And that is why, that is how they have decided 6.6. And my lord, as regards, now they have come to another finding, my lord, 9 members that I have not given the list of members. 9 members has complained during this meeting saying that they have not given me consent to file the tender, to participate in the tender. And those persons were asked to call upon before this managing director during the time of hearing. I sought for time, that is at page 68, last but third paragraph. Whereas on an application was moved by Joydev Das stating that all the members of the board of directors has pre-scheduled program to visit Prayagraj from Mahakumbh as they could not appear on such and such. On 15/2, it was from Joydev Das absent, whereas the letter dated such and such signed by him is in the record. Now, considering the whole matter in entirety, it is decided not to go for further hearing. Considering the revenue of the corporation and lingering the issue will incur loss to the government exchequer, and therefore rejected the PR made by Joydev Das on such and such, and decided to pass an order considering all aspects, as calling all the directors is useless formality, and as issue can be decided on the materials on record. So how he have decided that those signatures were fraud or nothing, and this managing director, he says that you don't need of calling that this is useless formality. And my lord, another issue that I want to place it before your lordship, there was a writ precedent.
Now, it appears that pursuant to initial approval that you have been technically qualified, they rejected your bid on technical grounds again. Against that, you filed a writ petition.
My lord.
Writ petition got dismissed, it
No.
seemed, was allowed.
It was withdrawn, my lord. Writ petition filed by private respondent number A, saying that the inquiry held, which I have shown on 18/11/24, should be taken into consideration while deciding the tender process.
Then,
My lord, one thing, my lord, before lordship, that they had suppressed another inquiry held in between their writ petition.
let us go back. Why there is a writ appeal?
Writ appeal filed by them, my lord, saying again that that writ appeal is in their affidavit. They have filed in that writ appeal. They have gone, my lord. That is
But-
they have gone again. That there is a direction that you take consider the that inquiry report dated 18/11/20.
So the writ appellate court directs for reconsideration of your technical bid.
Yes.
My lord,
And in pursuance to that,
my lord,
you have been held to be disqualified.
my lord, my lord, my
That
my
appears to be the case.
my lord.
But how did it go to the writ appeal?
My lord, the writ appellate court, that is, they have gone to the writ appellate court. It is in their affidavit I am stating, my lord.
How?
My lord. But
If the writ petition was withdrawn, how did it go
no,
to
no,
the
writ petition filed by them, there was a direction that you take into consideration that 18/11/24. That is at page, your lordship will
Then
find.
who filed the writ appeal?
My lord, it is their writ appeal. They have filed a writ appeal, my lord.
I think my learned friend is.
Page 138, your lordship will.
My lord, one writ petition was filed by us saying that their technical bid should not be considered. There was a writ appeal therefrom, maintain the same order. They also filed a writ petition which was withdrawn. That my learned friend is not in.
My lord, I have withdrawn the writ petition which I have challenged. The writ appeal filed at page
You,
130.
Mr. Roychuri, I asked you, you said that they have withdrawn.
No, my lord, I have filed a writ petition while challenging that order that you have annexed, my lord. Your lordship will find that order is there.
Let us see the writ appellate order.
Writ appellate order at page 136 in their affidavit.
Okay, wait. Before that, let me see another. Who is Manoj Das?
No, the private respondent.
He filed the writ petition.
My lord.
Third annual review, learned counsel who submits that the petitioner participated in the tender process for settlement of orphanage for six. Our counsel submits that the petitioner and the respondent number have been both declared to be free. The submits that income to that is a repeat money, which Indian work will be I have not been the member each of the from Petitioner submits that in view of the clause of 115 have been violated. Petitioner appears to be that the in view of the submission so and so shall consider that the one is a consequently take action with regard to the selection of constitution provision letter. There is a direction to the effect. IA is filed. IA filed before the division bench.
My lord.
Matter comes for consideration for delay of condonation of 15 days. Interally, therefore allow, since the controversy is based on with the consent of the learned counsel appearing, we have heard the learned connected feeling to challenge the action of the appeal. Who has the appeal? Who here moved us? Mr. Chaudhary, why did you file the writ appeal?
My lord.
Why did you file the writ appeal?
My lord, we filed the writ appeal against, no, anyway, my lord, that writ appeal was dismissed. That writ appeal was dismissed, maintaining the direction given by the learned single judge.
And hence the writ appeal is yet to be registered is dismissed. Okay, so against the directions passed by Justice
Michael Jotham Kumar.
Jotham Kumar, you filed a
Writ appeal which was dismissed, reiterating the direction issued by the learned single judge.
So your idea of filing the writ appeal is that it should have been, this court should have itself, instead of sending it to
Yes,
FTC,
decided the matter.
decided that. So that was dismissed. So
Yes.
therefore, the order passed by the learned single judge remains.
Remains.
Now pursuant thereto, they considered 11/8/2024 communication.
18/11/20.
18/11/20.
18/11/2024 communication they considered.
Consider.
And that communication says that the secretary of the society has not maintained the member register of the society.
Yes.
The management of the society did less circulation promotion of every year. Last AGM signature of the deceased and non so and so have been reflected in the AGM so and so, so and so, so and so. Now, this has been done and therefore you say that there is a violation of clause 6.6.
No, because clause, serial number 16 of the tender, read with clause 6.6 of the tender mandates, my lord, that a cooperative society, if they want to submit a bid, then there has to be a resolution of the board of directors. And lordship knows under the Cooperative Societies Act, under section 45, every such resolution has to be approved by the Assistant Registrar of Cooperative Societies. let my learned friend produce that resolution that as a society, secretary was authorized to submit the tender. That's the point which eventually the authority has decided. They found that.
Decided not to allow those person be brought before. That is a futile exercise. When those person was asked to call.
No.
Be-
That is not the issue. You see, for the purpose of, as per the Cooperative Societies Act,
Yes,
there is a requirement of having some meeting.
yes.
A resolution has to be
There's a
done.
concept of an annual general meeting.
Meeting
one
and
is the
any other
concept of a
meeting.
special meeting.
Malad,
Now, this will be a case of a special meeting.
special meeting.
One day is a resolution passed by the special meeting. There
Approved
is
by
a
the register.
requirement of an approval by the
register.
assistant register.
Register.
Now, do you have that?
My lord, our statement that what has been decided,
No, not the statement. The question is that.
we have placed the original before the authority. That is there. Finding is there.
No, the question is, you have submitted the original of the meeting.
My lord,
There's no quarrel with that.
my lord,
We accept that you have the resolution was passed.
my lord,
The resolution was
my lord,
passed.
my lord.
But the question is whether the resolution was approved by the assistant register is the short
No.
aspect. And is it required as per 45? That's all.
My lord, 45(1), my lord, if I can read it, my lord, if your lordship permits me. Every cooperative society shall record in the minute book in the official language, office station or in English or any other language prescribed in the bylaws proceeding of every general meeting, delegate general body meeting or board meeting, and the names of members and delegate present thereat, and shall be confirmed at the same of the next meeting. The proceeding of general meeting and special meeting of every cooperative society, complete in all respect as provided in the Act and bylaws, shall be sent to the register within 15 days from the date of the completion of such meeting with due acknowledgement. The register shall give approval on the resolution within 15 days of receipt of the proceeding. If no approval is received in the aforesaid period, the proceeding shall be deemed to have been approved. So, my lord, our statement is that it was deemed to have been approved.
Okay, very well.
My lord.
So when was it submitted and when it was?
No, that will be in the records, my lord. If
No. You are the petitioner.
My lord,
Mr. Biraj Chaudhary, you cannot trust on a fishing and roving inquiry.
because
It is you who has to come up out here and
No.
show that on this particular date, this we had submitted this year, the Eastern Register did not approve, and as such, it is a deemed approve. You want to rely on that, you have to make a statement and you have to give this evidence to that effect, because you are holding the management. So therefore, you will be having the peon book or whatever book
When it
by
was-
which you are sending it to them, which was duly received, and within 15 days, it was not given.
my lord. And thereafter, we have submitted to the authority.
Yes, where is that?
My lord, that instruction is yet to be.
Then that is the issue. Long and short.
My lord, another small issue is before your lordship.
There is no small issue. That is the only issue.
My lord, another because.
Let us not digress.
My lord,
If you have this, we go to the another smaller issue and give you all the reliefs. But first satisfy me on this issue.
my lord, that requires an instruction
After-
because. My lord, only another thing, my lord, if your lordship, but I
Can
do understand.
Allow on the other issue. Without that. No, you tell me. No,
Because
I gave you the liberty or give you the opportunity out there to make that submission, that can I allow the writ petition on that smaller issue when the larger issue is still there? Then tell me.
the whole case of them, my lord, it starts with that the inquiry report of 18/11/24, where there are some statements that some dead person names were there. They came before the court stating therein that that inquiry report has to be taken into consideration. In between the filing of the writ petition and that 18/11/24, there was another inquiry which they have suppressed before the single judge, before the division bench, even in the affidavit they have not stated. That is at page 46, your lordship.
Were you a party to that earlier proceedings?
Which proceedings, my lord?
Earlier proceedings which ended with that order by which 18/11.
Dispose of in motion, my lord. Dispose of on the very day, I think, my lord.
So why didn't you file an appeal?
Well, because on 18/11, when it was there, and this document was placed before the authority, the managing director.
No. See, why didn't you file an appeal? You knew about this.
No.
Why didn't you file an appeal that it was passed ex parte against me without taking into consideration this?
That was,
If you have not filed an appeal, you cannot have that grievance in a collateral proceedings.
Then, my lord, on that instruction of 6.6, if the whole place is revolves around 6.6, my lord, we will place it that.
Your basic case is that 1811 is there,
My lord.
but there is another report which was not taken into consideration.
My lord.
But that report is nowhere there anywhere,
My lord.
and this court cannot take it unless we hold that
My lord.
that the order passed by the coordinate bench is a nullity.
My lord.
Isn't that the basic fundamentals?
My lord. And then, my lord, then the question of 6.6, as regards, my lord, in between that decision of 1811-24, my lord, there were 9 members who came before that we have not given consent. And we made a prayer that we may be allowed to bring those directors before the authority. Then we made an application which was rejected, saying that it is
No,
a-
whether they give a consent or not, that is immaterial.
My lord.
But the question is, can you get it, the resolution which has to be placed has to be an approved resolution.
approved.
Normally, what happens out there, they give within 15 days, they are required to give the approval and otherwise to reject it.
Reject.
I think I have passed a judgment on that as
My
well.
lord, my lord.
Section 87 also has a similar.
Yeah. So it has to be rejected. Otherwise,
Deemed to be approved.
there is a deemed approval.
My lord.
You have to show me that. And if that approval is there,
My lord.
that has been submitted,
My
then
lord.
6.6 or 16 have been duly complied with.
Completely compliant.
So then nothing remains.
Doesn't it?
So you are a win-win, but you have to satisfy.
That documents will be filed through an affidavit.
This court I have heard Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner, Mr. K.N. Chaudhary, the learned senior counsel, assisted by so who appears on behalf of the private respondent, and Mr. P. Sharma, who appears on behalf of the AFDC. The issue which is involved in the instant proceeding. Now, full stop. It appears. No, full stop. The instant petition has been filed challenging the rejection of the technical bid of the petitioner on the ground of non-compliance with clause 6, read 6.6, clause 6.6, read with clause 16 of the notice inviting tender. Full stop. In terms of clause 16 of the notice inviting tender, there is a requirement of submission of a resolution in the case the bid is been submitted by a cooperative society. The petitioner admittedly is a cooperative society. The issue which is involved is as to whether the resolution which was submitted by the petitioner along with the bid is in consonance with a resolution of a cooperative society recognizable in terms with the Assam Cooperative Societies Act 2007. Taking into account this court, Mr. P.K. Roy Chaudhary, the learned counsel, submits that certain instructions would be required in this regard. List this matter when.
Just on the opening, madam.
Okay. You want it on the opening? 14, 15, 15?
15, 15.
Mr. P. Sharma has lots of difficulty.
I have some after 18 lots.
He won't. And why 18 then? Means he doesn't want to, he has taken a longer break. So we have it on 28. On 28, 10, 2020.
Lordship, may I submit some permission, Lordship? May I submit though in 6.6, Lordship, there is a requirement that they have to. They are not supposed to give the original copy. We decided the genuineness. If they submit the original copy, they cannot give the original copy to us because cooperative society's copy cannot be original. It has to be signed. In the clause there is we have
understood because the original has to be submitted to that. I think this issue, what I have framed, will have it everything.
My lord, instead of 28, could it be 23, my lord? 28 I have some difficulty. Or maybe 30.
On 23rd.
Yes.
I don't know.
Diploma. Item 14.
That petitioner is a manufacturer of drugs, my lord. Some drug was ordered to be supplied, my lord.
Here is a blacklisting, case of blacklisting. My lord, your losses may come to page 44 directly, my lord. The clause, my lord, which is debarment or blacklisting.
Page
44. Right.
Yeah.
My lord, there are two types of debarment. Debarment, blacklisting for failure in execution of supply, non-supply, default in supply. Product debarment. This is one product debarment. In case of non-supply or incomplete supply, at least so and so, by the approved manufacturer, importer, within the agreed delivery period, including the delay penalty period or any such extended delivery period, then the concerned rate of contract shall be cancelled and the manufacturer importer shall be debarred from participating in any bid of the authority for 5 years from the date of debarment for that item. In case manufacturer importer firm supply 90% or more the ordered quantity but fails to supply the entire quantity within the allowed delivery period, then the firm shall be levied a penalty of 10% of the value of the source supplied, and the same shall be adjusted against the payment for supply. And firm shall be blacklisted and debarred from participating in tender by the TIA or the procuring agency for a period of 3 years if the company is debarred from for all items where RC contract is far less than 3 items, or at least 3 items where holds that contract for more than 3 items. My lord. This is the, my lord, clause, my lord.
Now what happened?
My lord, here what happened, my lord? There was delay, my lord. We prayed for, my lord, extension of time because.
Where is the impugn order?
My lord, I'm coming, my lord. Before that, my lord, I have to show, my lord, because we manufactured, we given the transporter, my lord, made some delay. So we submitted an application for some grants of some extension. And now your losses may see page 94, my lord. With reference to your letter submitted so and so, requesting for extension of delivery period from your end, and for the 25 number of your without mentioning item details, where the COD and time with the highest financial penalty, 2% per week, up to maximum 10% are already over, and extended delivery period have over. Therefore, I am directed to inform that against every PO for which you have registered for extension should also include the item name and tentative date of supply from your end. Kindly resubmit the extension request by tomorrow, mentioning the above mentioned information for owner submission to the official authority for taking necessary decision on this area. Now, my lord, we have submitted the next day. The next one, page 95, my lord. On the same day, my lord. Same day we have submitted. Now, this has not been considered, my lord. Without considering the same, my lord.
Date of the impugn order?
Date of the impugn order is, my lord,
So here you have not been done for product, you have been done as
25.
per firm debarment.
My lord?
They had firm debarment.
Firm debarment. My lord, here, if you'll also see, my lord, that one notice has been issued, my lord, because we submitted our petition same day, but that was without passing any order on that, my lord. The managing director issued a notice, my lord, at page 97.
Page
97.
96.
97.
Yes.
And the operative portion is page 98, my lord, you also see. Last paragraph. You are hereby asked to show cause why your products should not be debarred as per the referral panel clauses of the tender. Hence, you are submitted 11 to show cause notice within 3 working days upon submission of the reply, administrative as well as financial penalties for levied as per relevant rules and clauses. So this notice has been issued, my lord, for the debarment of the product, not for the farm, my lord. Now, my lord, we have.
But they have debarred the firm.
My lord. That too by general manager, my lord. It is, my lord, if you also find, my lord, there are several letters, my lord, which were issued by the general manager with the approval of the managing director. But here, my lord, the so-called notice has been issued by the managing director. Then we have submitted the application, my lord, that our products has, my lord, come also.
But in spite of that, my lord, at 105, my lord, this letter is issued, my lord, by the general manager. And that too, my lord, was some purpose facts, my lord, because some of the goods we have supplied 100%, but they have said that we have not supplied 0, my lord.
They are referring to some clause 5. What is
Yes.
that clause 5?
That is only for 5 months, and I have referred to.
Huh?
Just.
You are only referring to there is some agreement. Where is that agreement?
In the academic follow there, please.
Okay.
Yes, yes.
What are they referring to?
My lord, at page 145, my lord. Yes. Huh? Or the- huh? I'm sorry. Oh. My lord, that page
This is the letter of
60
intent.
166, my lord.
This too you have also included. Where is the agreement? Yeah, got it.
165. my lord.
165.
165.
So they have acted as per clause. Where is that?
Lordship, may I have a look at this box, well?
Huh?
Here, everything will be clear. Lordship, may I have a look at this box? Lordship will find that at page 16.
Which clause you are referring to?
Page 16, Lordship will see.
Page
16.
Ah,
Then subclause H is at page 22.
page 22.
Yes. Sir. H. Product debarment, firm debarment.
Blacklisting for failure in execution of supply, non-supply, default in supply. Product debarment in case of non-supply of the complete supply of 90% of the so-and-so within the agreed period. So-and-so, the delay penalty period or any other so-and-so shall be cancelled and the manufacturer shall be debarred from participating in any bid called by the authority for the years so-and-so. Called by the authority 5 years from the date of debarment for that item. In case the manufacturer importer supply 90% of it from debarment, the firm shall be blacklisted and debarred from participating for future. Now, let us see your notice.
Yes. Notice is, my lord. 97 line.
M is different. Alternative of purchases. Debarred as per the referred penal clause. M. If the empaneled supplier fails to execute the supply within the stipulated, the MNA is at liberty to make alternative purchase of the item for which the purchaser placed for any other source such as so-and-so or in the open market even at higher risk at the risk and cost of the demand. Event of making alter the supply which will be imposed penalty apart from forfeiture of demand. The expenditure of demand in making such purchase many other source of power shall be recovered from the secured pay. So you are acting on terms of what? Clause 5M.
Yes.
Clause 5M does not say about debarring.
No, it's clause 5. Lordship will see page 97, last para. Hence, in the greater public interest, you are asked show cause why your product should not be debarred as per referral penal clause of the tender, that is clause 5 of terms and conditions, subclause H. Debarment, blacklisting for failure in execution of supply, non-supply of so-and-so. One says, point number 1, product debarment. Where it was.
So therefore, your notice was for product debarment.
No, Lordship will turn to page 98 again. Point number 2, second page, my lord, in the right hand side, second line, my lord, in the first para, in the right hand side corner, Roman 2, firm debarment. Then in the fourth from bottom of the said para, Roman 3, forfeiture of performance security, everything was mentioned.
Okay, then
Then, my lord, the impugn order.
they reply, we here recognize your letter dated here, we have successfully completed over 80% of the required supply to so and so and the remaining are currently in Guwahati. Our due to closure of the relevant purchase orders, we are unable to deliver the pending item. Regarding annexure A serial, we confirm that 100% of the quantities were dispatched. Unfortunately, due to mishandling of the transporter, the remaining quantities were not allowed. So and so, if you are granted an extension of the project, you will dispatch it, so and so. Then, managing director, then what is your reason? Found that the tasks were essential for so and so, therefore, in greater public interest, hereby blacklisted and debarred from participating in tender for 3 years. But, then you also go for alternative.
Yes. We'll have, my lord,
So
immediately.
here the fact does it remains that they could not supply 90%.
Yes.
They supply 80%.
No.
Yes, that's what they say.
Below
Yes.
80%, my lord, below
My
80%.
lord, some of the products they have shown as
Page
zero,
99.
but we have
Page
supplied
99,
100%.
Lordship will see.
We have shown 100% also.
Page 99, this is the annexure A. A of the show cause. Lordship will see, my lord, number of days passed since approval. Maximum 75 days is the time to, my lord, supply.
We are
200,
concerned with serial.
no, all these, my lord, is a part of the show cause. These are their delays.
Okay.
Lordship will see the last part, my last column. Days passed since approval. 233 days, 232 days, 270, 232 days, 147 days. Well, we one medicine, my lord.
My lord.
In this way, my lord, medicines are supplied. We cannot ask the patients to
Oh,
wait. my
yes,
lord.
yes, no case.
My lord,
We
you
cannot
are-
ask them
no,
to wait. Very
I'm coming, my
casually,
lord.
my lord, the,
I am coming, my
our
lord.
state has been dealt
Here,
with by the petitioner.
item number 5, if you also see, my lord, folic acid, they have shown it is 0% supply. We have supplied 100%.
Why didn't you reply?
No, what that, and before that.
No, why didn't you reply in your so cause?
So of course, my lord, we have, so cause is only for product department, my lord. If you also see.
No, all.
No, your losses must see again.
No,
My lord, page 97. Page 97, your losses must see. They have quoted only the clause. Hence, in a greater public interest, you are asked to show cause why your products should not be debarred as per the referred clause, penal clauses of the tender. Now they have quoted this.
Then?
They have quoted this, my lord. So,
And
show
not
cause
only
is.
that,
My
they
lord,
have product debarment as well as firm debarment
no,
also.
that is, that clause has been quoted, my lord.
Then?
But show cause why should not be debarred as, my lord, your loss, product should not be debarred. Your losses must see. Page 97 and 98 both.
No.
Asked to show cause why your product should not be debarred. And 98 last para also, same thing. 98 last para also, my lord.
So you have no problem in the debarment of the product.
My lord, I'm coming, my lord, to that, my lord, because they have
No,
not.
we take it that you have no problem as you are making that submission.
My lord.
No. We take it and ask them to issue another for firm debarment.
My lord.
As regards the product debarment, he accepts it.
My lord.
Admitted, my lord. Open.
He's admitting it.
Yes.
So we allowed your petition saying that the product debarment is okay, but firm debarment you take action again further.
But
And the 3 years will count after that 5 years. Do it.
My lord. My lord, not that,
H
my lord.
Roman 2 is very clear, my lord. Why we have to go for that, my lord? Ultimately.
Understood everything.
And now, another, my lord, I have shown, my lord, that the first thing, my lord, our application has not been considered, although they have said that you file it tomorrow, we shall consider it. First thing, my lord, we have prayed for extension, and they say that you submit an application by tomorrow so that it can be considered by the appellate authority. They have not considered it. They have not passed any order, and thereafter this so cause has been issued for product debarment. My lord, I shall place, my lord, that because here no hearing has been given also, and moreover this.
What hearing?
Hearing.
No hearing. Hearing
Yes,
is not required.
Yes, my lord, required, and now I shall place, my lord, various decisions of our High Court as well as Supreme Court also, my lord. I shall place, my lord.
You are then you should have approached there
My lord.
for hearing or go where is there alternative remedy not there? Civil court, na? Go to civil court. If you are asking this court to give you a hearing. whether
Hearing
this-
part, I have got a judgment, my lord. My lord, my lord, that show cause, and my lord, reply to the show cause is an act. It doesn't mean that there will be a personal
No.
hearing in every case. but
My lord, even in,
I've got judgment to
in
that.
similar case also, my lord, this matter has been demanded back, my lord, for personal hearing. And moreover, my lord, the losses may see, my lord, we are letters, my lord. If you also see the letters, my lord, the general manager, how he can issue, my lord, your losses see page 173. At page
Mr.
1.
Traveler, the thing is okay, we go for the debarment, firm debarment, product debarment, we ask them to debar it, it's okay, but firm debarment, we ask them to show cause again. Okay.
My lord, virtually, my lord, so
Then
far.
you leave out that argument, don't make that argument, that argument has far-reaching
No,
consequences.
my lord, why I'm arguing, my lord.
Then you may say
They-
that, okay, farm debarment, the product debarment means the batch of the product, not others.
My lord, here what happened, my lord? They have not debarred my products, my lord. They have not that order finally. And moreover, my lord, I have challenging my lord, general manager also, my lord. Because the earlier, if you also see, all the letters have been issued with the approval of the managing director. Here, everything has been done by the managing director. General manager is not naughty, my lord. If you also see page 174, my lord, of the affidavit, my lord.
Yes.
173 is the letter at page 174, the last but one sentence.
Yes.
This letter is issued as per the approval of the managing director.
Right.
At page 174, last but one sentence. Similarly, at page 176.
Okay, then.
That page 176, the last sentence.
So these have the approval of the managing director.
Yes.
Then?
Then, my lord, then another 184.
So you say that the
184 also.
impugn order was passed
Yes.
by them.
Yes.
By an authority who was not empowered.
Not
Para 15 of the affidavit, my lord, page 131, we have replied. He has been authorized, it is categorically mentioned, my lord, in our affidavit. Page 131, para 15.
These statements, my lord,
We have dealt with on this aspect.
There is no reply filed.
Like could not be filed, my lord, because it was sent, but could not, my lord, it did not come, my lord. We sent it for, my lord.
You want to file reply?
My lord.
Better off. There is no stay.
No statement. No statement.
Long order has been passed.
Yes.
In fact, my lord, the interim was rejected. Interim was rejected.
No, in fact, so-called notice means blacklisting, if there is an interim order, it has far-reaching consequences.
Yes, sir. Because
Because
we will
what
still have
happens,
to.
the big bidder, small is okay.
Lots of.
Where there is no pan-India implication. But otherwise, it has a lot of problems.
We have pen India, my lord.
So therefore, there is a blacklisting is also a problem. And staying a blacklisting also in the interim order has also a problem because those authorities where you are going to participate, tomorrow if your requisition is dismissed,
yes,
it will have a long, that you become ineligible.
Lots of.
Hello, Mr. I've given you the liberty to file the reply.
My lord. Yes, but my lord, it was prepared and sent, my lord, it could not come, my lord.
Mr. G.N. Saivara, the learned senior counsel, submits that the affidavit in reply had already been prepared but could not be filed on account of the fact that it have not arrived from
Uttarakhand, my lord.
Uttarakhand. So accordingly, list this matter on 20. After filing of the reply.
Well, we shall file in that one. No, not
29th October.
Yes.
29th October.
At 2 p.m.
At 2 p.m. You have not been successful. bring this on record by
Well,
filing an affidavit,
yes.
somebody. A petition,
No, I will bring it.
the entire agreement on the agreement in entirety be brought on record by filing an affidavit by either of the parties. Yes,
Well, my instruction, my lord, as per my instruction, they stated, my lord, the last date is 3rd of October. So if still there is time, if he is in the wrong impression that it will not be issued, let him approach, it will be issued, my lord, provided
may be
they are
that-
satisfied.
My lord,
no,
that
no,
may be
there
recorded.
cannot be a satisfaction if he has gone out there with
Apply, my lord.
these longitude, latitude and all. Where is your photograph?
Page 20.
Mr. Counsel, where is the person in the photograph? How do we know that you have taken the photograph? Oh,
That geotext photo. will
Geotext
have to be-
photo I submitted, my.
where are you?
Yes, you have to.
Anybody can go out there and take the photograph.
My lord,
But I think Mr. Gogoi,
My lord,
that day I passed an order
my lord.
in case of Mr. Bidida.
Last year.
There, have you seen my directions?
Yes, my lord, in fact,
This court directed upon submission of the photographic evidence along with the geotech location, the respondent number 3, who is the concerned engineer, shall countersign the site verification which shall be duly already been submitted by the petitioner on so and so before the respondent number 3. I say, this court further observes that after submission of the site verification certificate signed by the petitioner, along with photographic evidence, the petitioners would be stopped from taking any plea at a later stage that the site in question was not conducive for carrying out the work in question.
that is the main objective and purpose of this particular clause. Sir.
So therefore, I have put.
In fact, in the very first order, also, Lordship will describe, my lord, why it is necessary.
So here also, I
I-
put it.
I'm obliged, my lord.
Let me allow it.
Yes, yes.
And
No, we are not
allowing it,
objecting to
yeah,
that.
he cannot take that later on, say
Yes.
that we have not gone into.
Because in most of the cases, we have found that, my lord, ultimately they go for arbitration. They say that there is some.
No. So
It's
this
not
order is.
possible.
yes, my lord.
Heard Mr. A.Y. Chaudhary, the learned counsel appearing on behalf of the petitioner, Mr. B. Gogoi, the learned additional advocate general, Assam, who appears on behalf of all the respondents. The petitioner herein is aggrieved by the non-issuance of the site verification certificate in terms with clause 7 of the 7.0 of the information and guidelines for the bidders, which is a part of the notice inviting e-tender dated 19/8/2025. It is the case of the petitioner herein that the petitioner, pursuant to the notice inviting e-tender dated 19/8/2025, have visited the site in terms with clause 7.0 of the instruction to the bidders, instruction, information and guidelines for the bidders, and submitted a communication dated 18/9/2025 to the superintending engineer PWD. That is the respondent number
Oh.
3 to the instant proceedings. In spite of, along with the said application, the petitioner have also enclosed the geotech photographs so taken. The grievance of the petitioner is that pursuant to the said communication, the respondent number 3 have not issued the site verification certificate. And it is under such circumstances, the petitioner has approached this court. This court takes note of.
Also, my submission that, my lord, he has approached this honorable court on apprehension, my lord. Till date, it has not been rejected, so let him approach.
This court approached this court. This court inquired with Mr. B. Gogoi, the learned additional advocate general, who appears on behalf of all the respondents as to why the site verification certificate have not been issued by the respondent number 3. He submitted that the petitioner has approached this case on an apprehension that the site verification certificate would not be issued. The petitioner can very well request the respondent number 3 for issuance of the said site verification certificate, and the same would be duly issued. Full stop. Per contra, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that this court, that the last date is on 3/10/2025. Full stop. In the circumstance that the petitioner is not being, if the petitioner is not being issued the site verification certificate, the petitioner cannot participate in the sender conditions. He further submitted that today and tomorrow are the last working days of this court. Thereupon, the court would this court would remain in recess on account of the puja holidays. Taking into account the above submissions, this court, in addition to that, the learned counsel for the petitioner also submitted that in the circumstance the respondent number 3 does not issue the site verification certificate, the petitioner would be deprived of participation in the said tender process. This court have duly heard the learned counsels appearing on behalf of the parties. And have also duly perused clause 7.0 of the information and guidelines to the bidders. First off, it is the opinion of this court that in terms with clause 7.0, the bidder has to acknowledge that he had examined the site work and its surroundings and have obtained all information that may be necessary for preparing of the bid and entering into the contract for construction of the work. Under such circumstances, this court does not find any reasons on the part of the respondent number 3 not to issue the site verification certificate. This court also cannot be unmindful of the fact that the materials on record only mention that the petitioner have visited. This court also have perused the communication enclosed as Annexure 2 to the petition, which is the request made to the respondent number 3, dated 18/9/2025. And along with that, the geotech certificates, geotech photograph have been enclosed. It is, however, uncertain as to whether the petitioner had visited the sites in question, inasmuch as it does not appear from the said document that the petitioner had visited the site. Taking into account the above, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the petitioner herein is not adverse to submitting photographic evidence of the visit of one of its partners to the site in question, and submit the said documents, said photographic evidence before the respondent number 3. He further submitted that the same would be submitted on or by tomorrow. Tomorrow before the respondent number 3.
They may it be day after tomorrow, my lord. One day.
Saturday is a holiday.
Holiday.
Tomorrow.
Yes.
It is the opinion of this court that submission of photographic evidence of one of the partners of the petitioner firm with geotech location would suffice for the respondent number 3 to countersign to issue the site verification certificate. on the basis of the photographs containing the geotech locations. It is also the opinion of this court upon a reading of clause 7 and considering the above, this court therefore disposes of this petition with the following observations and direction. The petitioner herein is given the liberty to visit the site for which the petitioner intends to submit its bid and thereupon submit photographic evidence of one of its partners' visit to the site with geotag location to the respondent number 3. Gusto. The same be done. Mr. A.Y. Chaudhary submits that the same would be done by tomorrow. Gusto. This court directs that upon submission of photographic evidence along with the geotag of one of the partners of the petitioner firm, along with the geotag location of the site, the respondent number 3, who is the superintendent engineer, shall issue the site visit certificate to the petitioner forthwith. This court further directs that the respondent number 3 shall not insist that the photograph should be taken in presence of PWD officials. Number 3. This court further observes that after submission of the geotech photographs and taking into account the request made by the petitioner to the respondent number 3, dated 18/9/2025, the petitioner would be stopped from taking any plea at the later stage that the site in question was not conducive for carrying out the work in question. Good stuff. Next. Before parting with the record, this court, however, makes it clear that this court has not decided anything as regards the eligibility of the petitioner pertaining to the detailed notice inviting tender dated 19/8/2025. A copy of the instant judgment be furnished to Mr. B. Gogoi, the learned additional advocate general, who shall duly intimate the respondent number 3 about the present directions.
Admission is item 22.
22.
Yes, anything?
Yes, Paul. Good luck. Lordship will see same paragraph has been repeated. In 45 lakhs.
$41 lakhs.
41 lakhs.
So he is entitled to the amount.
My lord, that petitioner's claim is, my lord, to the amount of rupees 41 lakh 74,300. So lordship will direct them to verify, and whatever is due should be paid, my lord, within the time frame.
Along with interest.
Amount has not been mentioned, my lord, but
You are reading the same thing. The same thing has been mentioned so
Yes.
many times. Paragraph 6, 3, 4, 5, 6,
no, this is
9,
the reply
10.
in all the, ultimately, my lord.
So therefore, I was just saying, on allotment of the work, the petitioner completed the work on so and so. Security deposit retained from the bill due to clerical error in the schedule of the deposit, that is Form 79 in the month of January and February, in which closing balance of rupees of January 2025 was not entered in the opening balance for the month of demand. As a result, an amount of rupees went missing. The matter was again already reported to the higher. On receipt of permission for payment of the SD amounting to 243,45,439 will be deposited in the head of account and then SD may be released smoothly. Next case, same.
Same, madam. Amount will be different. But madam, in the next case, it is madam 45 lakhs. In the present case, 41 lakh. According to the petition. In the prayer portion, page 20.
In this case, he is asking for how much?
41 lakh 74,300.
Now, have you received the money?
No, my lord.
No, no.
My lord,
It will be now credited to the head of the account.
that
This is
my
what
lord,
has been mentioned.
I don't think so, my lord. It's not been mentioned anywhere.
Huh?
It has not been mentioned. So Lordship will give us some reasonable time. It will be, my lord, we'll have to work out. And it will
You
have.
file an affidavit
I will file my application.
through the chief engineer.
Lordship,
Because this is by the executive engineer to the chief engineer.
Lordship. Today I got it, my lord.
Huh?
Today I got the instruction, my lord.
You file it by next week.
Lordship.
On reopening, I'll take,
My lord.
because with the affidavit of the chief engineer, we'll incorporate it.
My lord.
When the payment would be made, because it is an admitted fact that you are entitled.
Yes.
It is on the ground that there is some payment not made paid.
Yes.
Some amount has to be put in the head of the account.
Wrongly, my lord, it was.
Huh?
Inadvertently, it was not accounted, my lord. It will have
So
to-
head of the account. So under such circumstances, I direct the chief engineer to file an affidavit within what time that amount would be remembered to you.
Lots.
Obligement.
So pursuant to the order passed on 17/9/2025, this court have duly taken note of. Mr. B. Gogoi has placed before this court a set of instructions issued by the executive engineer PWD to the chief engineer PWD. Full stop. From a perusal of the said instructions, the said instruction is kept on record and marked with the letter X. From a perusal of the said instructions, it appears that the entitlement of the petitioner to the refund or the security deposit is not denied. It, however, appears that on account of there being on account of certain payment not being deposited in the head of account number 448443, etc. The amount the security deposit amount would not be closed. Full stop. This court fixes this matter on 17/10/2025. Full stop. The chief engineer, PWD department, PWD bracket border roads and NEC works Assam is directed to bring on record that stand as to when the petitioner would be paid the amount of security deposit as claimed in the writ petition and to file an affidavit as to when the said amount would be paid. List accordingly. ইখনতো X করে দিব, হ্যাঁ? Yes.
But the amount will be different in the other case.
I have not put the amount.
Lots.
But, amount, I have not therefore put the amount, I have said security report. Both are security reports.
What are
Yes,
security
same,
deposit? Same tender. Okay.
Yes, what is this?
My lord.
What instruction? Did you get that instruction as regard 4,
Yes,
14?
my lord. My
What
lord.
is it?
I'm blessing it.
Did he comply with the police verification or not?
Not my lord.
What is the name of the petitioner?
Oh, my lord.
Sanmia.
Chan Mia, my lord.
Huh?
Sanmia.
Sanmia. Rejected due to insufficient documents.
My lord.
Insufficient document. What is that insufficient?
My lord, I have produced the resolution also, my lord.
No.
Committee.
Self-affidavit, no. He also did not give. Number one also did not give. Then what is it? Accepted here, police basin, no and non-encumbrance not given. NOC for Kopatara not given. Here up to date registration not given. What is it? Where? Resolution? This one? SMEs?
Yes, my lord. My lord, I'm reading, my lord. The second page, my lord. This is it's regards to this particular market. Pratham Pastab.
Did not submit the police verifications report.
Yes.
Well, it was not rejected on this ground. Well, kindly see paragraph 3 of my rate petition, page 53 of my rate petition.
No, you see this.
This is resolution.
From the resolution. Where are you reading?
Resolution, I do not know, my lord. It was to be settled by the Gaon Panchayat, but the Anchalik Panchayat is unnecessarily involved in the matter.
These Anchalik Panchayat, they do it. Can't help it. Who has issued the tender?
Well, it is BDO and secretary.
Where? Where is this thing? Police verification? Yes. Number 5, na?
Yes.
Is that also?
My lord.
Number 5?
My lord.
I don't know. Number 5, na? Adi,
My lord, number 1, my lord.
number 1 only.
One is Bir Singh Jogomaya Khat.
Okay.
Bir Singh Jogomaya Khat, no?
You do one thing. You have taken the instruction. You file, you put it on affidavit. I'm not staying it.
My lord. Yes.
So pursuant to the order passed by this court on 19/9/2025, Mr. S. Doctor has produced before this court the comparative statement of the Bir Singh Jogamaya Ghat
And one written instruction is also there, my lord.
as well as the resolution
Dated 18/8/25.
18/8/2025. From a perusal of the said documents, it appears that 9 numbers of tenderers have submitted the bid against the Bisan Jogmaya Parghat. And during the scrutiny of those tender papers, it was found that the petitioner and one Suzab Ali, respondent,
Number 7.
number 7. The respondent number 7, tender value was same. Full stop. However, on scrutiny of the papers of both the tenderers, it was found that the petitioner did not submit the police verification report as mandatorily required under the terms and condition number 19 of the NIT. So it was also found that the passport size photograph pasted by the petitioner on his tender paper was not duly attested by any gazetted officer as mandatorily required under condition number 17. Apart from that, the copy of the both registration certificate submitted by the petitioner was not clearly visible, which it was required as per serial number 8 of the tender form. and the boat insurance certificate was not submitted by the petitioner in his tender form. Taking into account the said, this court is of the opinion. This court is of the opinion that the said aspect be brought on record by filing an affidavit so that the petitioner would be in a position to rebut to such allegations. Full stop. This court further this court further taking into account the above instructions is not inclined to pass any interim order. Full stop. Mr. Kekite, appearing on behalf of the petitioner, submitted that in the as this court is not inclined to pass any interim order, the matter may be taken up for disposal at an early date, taking into account that the period of settlement is for
1 year.
1 year. Full stop. Accordingly, the affidavit be filed on behalf of the respondent authorities as well as by the private respondent on or before 15th of October 2025. Liberty given to the petitioner to file a reply on or before 22nd of October 2025. List the matter on 23rd of October 2025 for disposal.
But I have no document, but I have oral instruction that respondent 7 has also not submitted.
You have a look, let them bring it on record. But you file your affidavit, don't say later on. It is observed that if no affidavit is filed by the respondent authorities, this court shall further consider the veracity of the documents which have been placed before this court.
That may be kept in.
No, I'm not giving him a chance there. I'm asking you to file an affidavit. So if I keep it on record, then it is already there. Therefore, I say that the veracity of the documents. Okay. Yes.
Your lordship said directed issuance of Dasti service on.
I'm happy to say. I filed my wakalat number today.
Why Numuligar is not retaining you? Yes, what is this?
The only thing is that lordship had not issued notice to respondent number 8. 8 was not issued. 8 is the person, my lord, who has been now entrusted to complete the work which was remaining out of the total work awarded.
No, you don't want to complete.
No, I wanted to complete. I wanted extension of 2 months of time. That was in October, last October. They did not grant me time of 2 months. This July, they have settled the contract with the respondent number 8 to finish the unfinished portion of work.
Then?
And alongside they have placed me on holiday list. They have held up my money, which is due and payable to me on account of the work that I have already done. I preferred an appeal. They have not disposed of the appeal as yet. And the situation is that.
Yes, Mr. Deka, you have
My instructions are that the work order was issued in May, my lord. Work order was issued in May 2025 to that respondent number. He is continuing with the workman. Now, so far as the blacklisting, holiday listing is concerned, my lord, that was done in January for a period of 1 year.
He has filed an appeal.
He has filed an appeal.
What have you done?
That has not been considered. As per I don't know, my lord, but what has
You
been
get
done.
your instructions tomorrow.
Tomorrow.
What have you done with the appeal?
Mine.
And if you can dispose it of during the vacations, matter over, please consider him. We keep the matter pending.
Yes.
You take a decision on
the appeal.
Because he has also filed an appeal. And the delay, on account of the delay in disposal of the appeal, he's been constrained to invoke the 226 jurisdiction. You take a call, instructions tomorrow.
I have my instructions back to me.
List the matter tomorrow at 2 p.m.
Man.
On which date? And Mr. Endeka appears on behalf of the
127.
NRL.
127.
127. Good stuff. Mr. S. Dr. Delaney, Senior Counsel, appearing on behalf of the petitioner, submit that the petitioner has approached this court against the blacklisting of the petitioner. Good stuff. Delaney, Senior Counsel, further submits that in spite of an appeal being preferred, no action has been taken and resultantly, the petitioner had to approach this court. Mr. Endeka shall obtain instructions tomorrow as to what is the stage of consideration of the appeal. List according.
Yes. So today fixed for instructions from the.
Yes, my lord.
Mr. Advocate General, can you hear us?
I can hear you.
We are told that you are not well.
Yes, sir. In fact, my last appearance was before your lordships on 4th September. After that, I didn't appear in any court, even on video.
Okay.
I'm
But you
appearing
look
today.
nice now.
I've lost 9 kilos. I was just telling my daughter, when I went 20 years back to Guwahati, I was like this.
No, Mr. Advocate General, we only wanted one thing. We have seen out there the High Court building, everything is done. But for the purpose of completion, there would be a requirement of contract for furnishing.
Right.
Because that is an aspect which has to be dealt with, because if all other things, 98% is already done. But if that is not being issued, making those supply or anything, we don't want to say how you do it, what you do it, but the furnishing has to be there. So there has to be some preparation to be made to that effect, how the furnishing would be provided. So that is the only reason why this matter otherwise is fixed on 23/10. But we have just wanted to, before vacation, inquire and just to put a little bit of a reminder to you as to how to go ahead with the furnishing. Because if we don't start the furnishing, under no circumstances it can be finished.
Right. In fact, I got intimation from the Secretary Law that the file is in process as far as furnishing is concerned. They are expediting the matter, and we'll have a recalculation of how much exactly would be required. What are the immediate requirements? I hope I'm audible to your lordships, my lord.
Yes, a bit, the volume is a bit less, but anyway,
Okay, so
I
I
can
will
tell
increase
you
my
to
voice.
the effect that the thing is, what is required to be done, but anyways, at the end of the day, it shouldn't be that everything is almost ready. Now, what is required is only the Chief Justice Court and the remaining 4 courts. The other 2 courts are now obviously will be used for the purpose of the bar.
That one, those
what
things
have
I
been
think
done.
we will discuss how the other courts are used on the next occasion. As far as, because we have to go for a protocol, a nationally accepted protocol.
Yes.
That the bar chambers are not mixed up with the courts for various reasons to maintain the dignity, security of the judges' courts. This will always be separate. There have been many incidents, even in Delhi, etc., in the evenings. It is happy hours in many places. So we don't want
But this would,
that even
this
on
would
a
of it
temporary basis.
save your
It is-
government with around,
No,
that
it
is what
is not.
we were made to understand last time. It would save
I
the
under-
government with around 70 crores.
I understand, my lord. And then what would happen ultimately, after the inauguration is done, this will be a permanent feature. We don't want that because then nobody will invest. We want the lawyers to have the opportunity of having very good chambers because we have space incidentally as far as the High Court complex is concerned. So we
No,
don't want to.
obviously, that is required, which you will obviously, I think there is
Correct.
also space also there. There's no quarrel there, there's no space. The space is
And-
there.
And we don't.
But the fact is, if it is, can be, otherwise there is no, if that is not done, there is no possibility otherwise.
We are exploring various methods as far as the lawyers' chambers concerned that cannot be given a go by at all, because after all, it's quite away from the town. So people will like to have their chambers, but never, even if it is a Supreme Court, not a single lawyer's chamber is there in the Supreme Court complex, main complex. At the most, on the side, not where the judges sit. You may have a place for the Attorney General or Solicitor General. Like that, even in our own High Court, in the old complex, we had earlier in 2005, we had a line of 6, 7 advocate generals on one line. No lawyers' chambers as such. Even presently in the new High Court also, it is not there. So the lawyers' High Court cannot, chambers cannot be mixed at all with the judges' functioning. That is one issue which we'll discuss later. That's not very important today. But that will not be a method by which we want to prolong anything. We want to expedite that also and to see from where we can get the funds, because fund is the main issue as far as those things are concerned. So even when we are going to go for the furnishing, we'll have one more relook at how much we have to actually spend for the moment, and how if there's anything extra we can take out, how it can be suitably utilized. I got a communication from the law department that this matter is under process as far as furnishing is concerned. So that is also in the process. Maybe by the next date, everything would be clear. I wanted to make it a point that I should appear today at any cost. If the case was the day of yesterday, I would not have been in a position to appear. My shape was not too good. Today, fortunately, we got the benefit of 1 or 2 days. So we take care of it. My additional AG expressed your lordship's concern last time that as far as the furnishing is concerned, we take care of it. Like there is
We
a
have been
saying
told,
in
Mr. Advocate General, that there is a likelihood of the High Court building seeing the light of the day this year.
definitely not this year, but in the coming year at the earliest. That much I can say. We are almost in a quite
But unless you
comfortable
have
position.
the furnishing and everything,
That will be
others
done.
okay. You take a decision as regards whether to have those courts or have to have as regard the bar, some other place out there, which is the
No,
building which is being
everything
constructed
has
out
been
there.
identified. Everything has been identified. The bar, chambers, everything has been identified. So in all fairness, when they were investing so much, the interest of the bar cannot be ignored. They must have the best
Oh,
chambers
we
available.
don't want that. We don't want
So,
that to be
and
ignored.
we don't
But
want
the
a
fact
temporary stay
remains
which
is,
becomes permanent.
but,
That is the problem.
but in that process, Mr. Advocate General, the
We are not going
only
to delay.
last time when we visited the site, you were there, very much there.
Right.
You were there when I had gone along with the Chief Justice. Then you were very much there. So the thing is, if at some point of time the High Court doesn't comes up, someday or the other it has to come up. In
Well,
the manner of construction which is going on the side as regards the bar, if it is getting delayed, something has to be worked out. And I know you can do your take care of with your good office, you can very well try and get it settled out there. We
Yeah,
have been
so-
told that there's a chance of someone the inauguration this year or next year in the first part of the post. But for that, some preparation has to be made as regards the furnishing.
we're doing it. Rest assured, it's in the process. In fact, once I came to know of it, I sent some messages to them. I got it in writing that the file is being processed in count. And even every expenditure, we have to be very careful also at the final stage. We don't want to slip here and there and become answerable later.
On a lighter note, Mr. Advocate General, on a lighter note, the Chief Justice has asked me if nothing is being done, I think you go and sit out there in Kohima till it is done something. So I may become a permanent feature in the Kohima bench.
We want you to remain even after we start the High Court there. We don't want to leave you behind. Because you have quite a lot of knowledge about the in and outs of the whole thing. So, so though we are going, we are not going to leave you behind. Definitely, I hope both of you will be there. We have 5 judges, and our judges' strength is very less. And we hope that our younger generation of lawyers get into the stream of judiciary, because unfortunately, the selection of lawyers as far as Nagaland is concerned, it's at a very ripe age where they are not able to really get into it. We haven't got a judge for a substantial period. It's quite unfortunate. I think those things would be corrected in due course. Until such correction takes place, we require the guidance of our present High Court also, so that we are tuned up to meet the challenges.
Mr. Advocate General, we'll do one thing. We have this matter again on 2310.
Anyway,
Give us some update as to what has happened in the meantime.
I will do it.
Any process, and I request you to take it from a good office and take it up with the authorities, so that something is done on that the furnishing aspect.
We will do that. No problem. I'll report back accordingly.
Mr. A.G. Balagopal, the learned edition and the Advocate General. K.N. Balagopal, the learned Advocate General. Nagaland has appeared before this court today through the video conferencing link provided. We have also heard Ms. T. Crow, the learned additional Advocate General, Nagaland, and Mr. H.K. Das, the learned Standing Counsel of the Guwahati High Court. Gusto. Further to that, Mr. R.K. Dev Chaudhary, the learned DY SGI, also appears. Today, the matter has been fixed. Today, the instant repetition is fixed only for the purpose of making an inquiry as to whether any contracts pertaining to providing furnishing of the new High Court building at Kohima have been issued. Gusto. Mr. Balagopal, the learned Advocate General, submits that there is a process ongoing, and he would like to provide an update on the next state as to what steps in that regard have been taken. Gusto, list the matter on 23/10/2025.
Okay.
Mr. Balagopal, we will request you to do something.
I will definitely do it. Let me be a little more fit to move. I will go and take care of it.
Yes.
I'm grateful.